So.
All right, is this going to be, sorry, I have two calendars. Come on up for Wheeler.
Yes, Judge.
Oh, Miss Pinto, you're first up.
I am, Judge.
Are you on the calendar tonight too?
I don't think so, Judge.
Let's see if we can't get you on there.
Appreciate it.
And if any of these don't have bond, y'all want to address bond?
Yes, Judge.
That way we don't have it, because tonight there's another marathon. Are you on there, Correa? It's like 50 some odd people.
Some of mine are on Thursday's calendar, but I will make those announcements as well.
Okay, yeah, so we'll address bond on any of them. Give Bostic something to do. All right. So right now we got Jamarcus Wheeler. That's 22 CP 1334, excuse me, 133348. 994 days without indictment, possession of prohibited items by an inmate providing prohibited items to an inmate. Obviously, that's not the only case for him to be in there, 994 days. All right,
Yes, Judge.
raise your right hand. Do you swear affirm testimony about to give is the truth, whole truth, nothing but the truth? All right, have a seat. And if you just speak up, make sure the court reporter can hear you. If you just keep your eye on her, where's she at? Where's my court reporter? Oh, where is the court reporter?
Here I am, Judge.
All right, so Ms. Jones, of course, you'll wave, turn your camera on and wave at him if you can't hear him, right?
Yes, I will.
Okay. All right, go ahead, and don't worry, Mr. Wheeler, this was the flu. Have no fever, I'm cool, it's not the Rona, okay?
Yes, ma'am.
All right, go ahead, guys.
All right. Permission to remain seated, Your Honor.
Absolutely.
Good morning, Detective Hammond. Thank you for being here. Can you introduce yourself to the court? Where are you currently employed?
I'm employed with Fulton County Sheriff's Office. As stated, my name is Deputy Brooke B. Hammond.
Deputy. My apologies. Okay. How long have you been employed there?
Of about a year and 4 months, sir.
What are your duties with your current agency?
Currently, I serve as the floor officer. At this time, I was the floor officer for 5 South. Now I'm assigned to the medical unit.
Ms. Jones, you can hear him okay? Ms.
Yes,
Jones,
Judge.
you can?
Yes, I can.
Okay, all right, just making sure. Go ahead.
Thank you.
All right. Thank you, Your Honor. Do you have any prior law enforcement experience?
Negative, sir.
All right. Are you post-certified?
Yes, sir.
Were you post-certified on October 18, 2022?
Yes, sir.
All right. What happened on October 18, 2022? How did this incident occur?
The morning of October 18, 2022, we were advised by our watch command that we was conducting a shakedown on 5 South Zone 500, rumored to be a cell phone inside of the zone. During our search, Officer J. Tidwell, Deputy Maya Merritt, and Deputy Mike Keno all were conducting a search inside of room 506. Deputy Merritt, she was the first to arrive. She was giving loud verbal commands for inmate Wheeler to remove himself from the room. Then Officer Tidwell began to go over to assist her and giving commands for him to remove the room. So finally, after a few loud verbal commands, they was able to get inmate Wheeler out of the room, and they went back in and searched. Deputy Merritt, she noticed that in the vent, the screws were loose. So she was able to turn the screws with her hand, and she found a white sock, which contained a charger. Officer Tidwell, under a mattress that Mr. Wheeler was laying on, he found a black and colored cell phone with a charger attached to it. It was not attached to anything else, just a black and colored cell phone with a charger attached to it. And Deputy Mike, he was also in the room present at that time.
All right. What is the address of this incident location?
901 Rice Street.
And is that in Fulton County?
Yes, sir.
All right. Can you explain more about the circumstances that led to the search of the room?
We got, like I said, we got word from our watch command that was a possible phone inside of there, and we conducted a search inside of that zone.
What is watch command?
Our watch commander, it's a combination of our lieutenants and captains.
Okay. At what point did you realize there could be a cell phone in the room? The cell number or the cell?
We were conducting searches throughout all the cells.
Okay.
And they so happened to go to this cell, which they found the phone inside of the cell.
Okay. And is it just Jamarcus Wheeler in that cell? Is there anybody else in that cell?
No, sir. That cell also housed at the time a Quantavious Ray, who was not present in the cell at the time. He was, I believe he was at court that morning.
No. How did you identify Jamarcus Wheeler?
How did I identify him?
Yeah.
We identified him using a 3-card binder, and it correlated with the cell that he was found in that morning.
Do you see the person in the courtroom today who was identified as a suspect?
Yes, sir.
Can you describe where he or she is sitting and what he or she is wearing? You can stand up.
Yes, sir. Jamarcus Wheeler is sitting at this table. It will be to the left of the deputy, wearing a navy blue Fulton County uniform with a blue face mask. Young black male.
Thank you. Your Honor, may the record reflect that the officer has identified the defendant, Jamarcus Wheeler?
So noted.
All right. Okay. With respect to the cell phone, both cell phones and the chargers, are they prohibited?
Yes, sir.
Okay. Was there any prior authority or permission given to Jamarcus Wheeler to have a cell phone?
Negative, sir.
And what was your role in this encounter? You're the deputy?
I was one of the officers conducting the search inside of there, and it also just happened to be my floor.
So you saw the loose screws in the event?
I did not witness the loose screws in the event myself. However, it was reported by the deputy and recorded on her camera.
And the charger was in the vendor. Where was the cell phone?
The cell phone was found under the mattress.
In cell 506?
Yes, sir.
And that's Jamarcus Wheeler's cell?
Yes, sir.
And that was Jamarcus Wheeler's mattress?
Yes, sir.
Where was the vent in relationship to the mattress?
The vent, so they have bunk beds inside the cells. The vent would be located, if you was to go in and have a sink, the vent would be up on in the upper area.
Okay.
Yeah, up there.
So it's relatively close proximity to the mattress?
Give or take about 8 feet.
But squarely inside of cell 506?
Yes,
okay. What time did this incident take place?
Approximately 7:22, according to the report.
Did anybody else, did you speak to anybody else about the cell phone and the charger?
As in?
Did you interview anybody else on the floor or the area? I
did not. At the time, then Sergeant Walker, who was he was the supervisor, he conducted a supervisor interview. He attempted to interview Mr. Wheeler. Mr. Wheeler declined to answer any questions. He didn't want to give a statement or anything. And obviously, Mr. Ray, he wasn't present to be interviewed at the time.
Okay. And you were pro-certified? Oh, what were you saying? Something?
Oh, he also interviewed Officer Tidwell, Deputy Mayor, and Deputy Mike.
And all these reports have been preserved?
Yes, sir.
And you were pro-certified on October 18, 2022?
Yes, sir.
All right. No further questions from the state at this time, Your Honor.
All right, Cross?
Thank you, Judge. Permission to stay seated?
Sure.
All right, it's Deputy Hammond, is that correct?
Yes, ma'am.
Okay. And as I understand it, you were not one of the deputies or officers who searched cell 506?
No, ma'am, I was not.
Okay, but you were doing searches on 5 South?
Zone 500, yes, ma'am.
Okay. And I just want to clarify, because I read the incident report and there was some varying accounts. So the cell phone, at one point it said it was found under a pillow. At another point it said it was found under a mattress. Where was it found?
According to I see what you're saying. The report, one officer says under a pillow, one officer says under a mattress. Regardless, that pillow is prohibited also. So if it was found under the mattress or the pillow, regardless, it was found inside of the cell.
Okay, but you yourself are unclear where the phone was found.
No, ma'am, I was not inside the room when the phone was found.
Okay, so you yourself are unclear where the phone was found.
Myself, yes, ma'am. But according to the report, that's what the report says.
And I understand that this search was at the behest of Watch Command. Are you aware of why Watch Command was under the impression there was contraband in the zone?
No, ma'am.
And you said there was another inmate also assigned to 506,
Yes, ma'am.
and that's inmate Ray.
Yes, ma'am. Quantavious Ray.
And he wasn't interviewed at the time.
No, ma'am.
Was he interviewed subsequent?
I cannot confirm or deny, ma'am.
So you don't know if he was ever interviewed?
No, ma'am. He wasn't there during the time of the incident.
But given that they're both assigned to 506, they both move freely within 506. Is that correct?
Yes, ma'am.
And how long was inmate or Mr. Wheeler assigned to 506?
I cannot recall at this time, ma'am.
So you don't know if he'd been there for years or if he had just been assigned there that day?
I cannot confirm or deny, ma'am.
And I understand that I think it was Sergeant Walker attempted to interview Mr. Wheeler. Was that interview or attempt, was that recorded?
Yes, ma'am, on this Fulton County body cam.
Was the search itself recorded on body cam?
Yes, ma'am.
If I could have one moment, Judge.
Sure.
Do you remember assigning Mr. Wheeler to cell 506?
No, ma'am, I do not.
Okay. And I just want to clarify, it was 2 chargers, but just 1 phone?
Yes, ma'am, according to the report.
And the vent you said was 6 feet, or the vent was about 8 feet from the mattress?
Approximately, ma'am.
So it was am I to understand that it was on the other side of the cell?
Yes, ma'am.
All right, nothing further at this time, Judge.
Any recross,
No redirect or recross, Your Honor.
just argument?
Yes, Judge.
This is your only case?
Yes, ma'am.
All right,
May our witness be excused?
absolutely. Stay safe out there.
Thank you, ma'am.
All right, and it's already got, so let me kind of clear up the record that he has armed robbery, ag assault, false imprisonment, kidnapping, and possession of firearm during, which is an indicted case, and he has no bond in front of Judge Ingram. So we'll hear from pretrial after we hear your argument on this case. Go ahead.
Yes, Judge, the state submits on the evidence subject to rebuttal, Your Honor. We ask that you find probable cause.
All right, Ms. Pinto.
Judge, I think there is an issue as to who the alleged contraband belonged to. There were 2 inmates assigned to the cell. The officer testified that he himself was not clear where the contraband was found within the cell. He testified that both inmates moved freely within the cell. He did not know how long Mr. Wheeler had even been assigned to the cell, whether he had just been assigned that day. So given all the issues, I would ask the court to dismiss.
All right, I'll go ahead and find, excuse me, probable cause on the possession of prohibited items by an inmate. And there's a $5,000 good bond already. So let me hear from trial.
Only car arrest is that an open case that got him in custody. Nothing further.
The one that's indicted in front of Judge Ingram. All right, go ahead, Ms. Pinto.
Thank you, Judge. Mr. Wheeler is 19 at the time of his arrest. I believe he was 17. So he's been in Rice Street for 2 years at least, Judge.
994 days.
Yes. He does have a bond on this case. We're just asking the court to reduce it. So once his indicted case, if it ever ends up getting resolved or dealt with, then he will have the option to bond out on this case. Of course, he has not been able to work in the past 2 years. So any amount of bond is difficult for someone in his position. But we're just asking for a reduction, Judge.
All right, what says the state?
Yes, Your Honor, the state will submit that a $5,000 good bond is reasonable here, fair and reasonable. With respect to Ayala, we'll submit there is a danger posed to the Fulton County Sheriffs, as well as a risk of perhaps reoffending. We'll leave this case we'll leave this matter in Your Honor's sound discretion. Nothing further from the state.
All right, since the other charges are extremely serious, not that this one isn't, and it's in front of Judge Ingram without a bond, I'll go ahead and reduce this to a $2,000 bond, no further contact with Quantavious Ray. No drugs, no alcohol, no weapons. No cell phones. No prohibited items in the jail, sir. $2,000 good bond.
Judge, could we, just since he doesn't have much control over where he goes within the jail, if it could just read like no intentional contact with Mr. Ray or something like that.
All right, no intentional contact.
Thank you, Judge.
All right, best of luck to you, sir. We got next. All right, who's your case?
Dominic Haynes.
It's position 14, Haynes.
All right, Correa. As soon as Ms. Sampson gets back down here, we'll get you, sir.
What?
I was talking to the officer that has Sampson's case. Now go ahead and raise your right hand. You swear affirm testimony about to give is the truth, whole truth, nothing but the truth?
I do.
Take some hand wash. It's just stuck your finger in your mouth.
I
And you
know.
know that table's disgusting, right?
Yeah, my bad.
Where is it at?
It's big old huge.
Oh, I see it.
Sir, might wanna try to keep you healthy. Yeah, let's see, we're gonna be, you wanna be heard on bond on this? Looks like he's been in 87 days.
Yes, Your Honor, and he is a position that has not been scheduled for your night court calendar.
All right. I mean, it looks like it's close enough, so. All right, this is position 14, Dominique Haynes, 22 CP 213573. 87 days without indictment, theft by receiving stolen property, possession of tools for a commission of a crime, fleeing or attempting to elude a police officer, reckless driving, speeding, driving with suspended license or revoked, and giving false information, driver failure to maintain lane or improper lane change. What says the state? Keeping you healthy.
Yeah. Yes, Your Honor. The state has called Officer Taharan John here. We appreciate him being here. Officer, where are you currently employed?
With the Atlanta Police Department,
How long have you been employed there?
just over 6 years now.
What are your duties with your current agency?
Currently, I'm a sergeant assigned to the FOD Zone 2, so patrol.
My apologies, Sergeant Taharan John. So your duties are largely take place in Zone 2?
Correct, currently.
Okay.
But at the time of the incident, I was with the Auto Crimes Enforcement Unit as an officer. We were tasked with locating stolen vehicles or vehicles involved largely from autos throughout the city.
Do you have any prior law enforcement experience?
No, just with APD.
Are you post-certified?
I am post-certified.
Were you post-certified on October 30th, 2022, the date of this incident?
I was post-certified on the date of the incident.
Can you tell the court about the incident that occurred on October 30th, 2022? How did your investigation of Dominique Haynes begin?
So Officer Ramsey of the High Intensity Traffic Unit was conducting LiDAR speed measurement on I-20. He observed the white Chevy Silverado traveling 94 miles per hour in a 60 miles per hour zone. As soon as the truck passed Officer Ramsey's position on the highway, it began making erratic lane changes and driving very recklessly. Officer Ramsey wasn't able to catch up to the white truck and gave a lookout for the vehicle. I was in the area of I-20 westbound. I got on right at Joseph E. Lowry, and I observed the truck speeding past me. My vehicle was equipped with a Star Chase, which is a sticky dart that with the GPS tracker on it. I was able to catch up to the truck and deploy one to the rear of it. Given the reckless driving, even without us activating blue lights behind it, we decided to go ahead and slow our speeds down and just use the tracking that way to try to keep the public at low risk of harm. The truck ended up getting tracked to 3187 Cascade Road. There was a single entrance neighborhood in that area. Officers began going to the location where the truck was in the neighborhood while I set up stop sticks, which deflate tires at the entrance. Officer Griffey was the one who found the truck. It had a single occupant in it. He activated his marked patrol vehicle's lights and sirens to initiate a stop. The driver once again did not yield and fled again towards my location. I was able to successfully deploy those stop sticks at the entrance, causing at least some of the wheels to be disabled. The driver lost control of the vehicle shortly after and crashed right near 3187 Cascade Road, which is located in Fulton County inside the city of Atlanta. The vehicle, like I said, was completely disabled from the accident. The driver door wasn't able to be opened. Airbags were deployed, and I believe it lost the front passenger side wheel, like the whole thing, like half the axle was missing. A single occupant exited the front driver window. That was Mr. Dominique Haynes. I was able to place him into custody without further incident.
Right. Is 3187 Cascade Road in Fulton County?
Correct.
All right. And when you first observed the subject vehicle, the Chevy Silverado on the freeway, where was that?
So I-20 westbound and Joseph E. Lowry. Joseph E. Lowry is located inside the city of Atlanta, inside of Fulton County as well.
Okay, so that your initial point of observation was also in Fulton County,
Correct.
where you saw the reckless driving. Did you see him speeding? Were you able to track the speed?
Yeah, Officer Ramsey with his LiDAR informed me that he measured the truck traveling 94 miles per hour. The highway right there, I-20 westbound, has a 60 miles per hour zone.
And what kind of truck was it?
It's a 2022 Chevy Silverado. Further investigation into the truck showed that it had been reported stolen by U-Haul through the DeKalb County Police Department on September 27, 2022. I looked up the value of the truck, and according to kellybluebook.com, the used car retail value of such truck is $44,883.
Okay, that's why you charged theft by receiving.
For felony level, correct. It was well over $1,500 in value.
Okay.
During my investigation, I asked Mr. Dominique Haynes his name and date of birth. He initially gave me the name of Kequan Jenkins, KEQWAN and he gave me the date of birth of December 14th, 1999. Both were false.
Did he have a driver's license on his person?
No, he's unlicensed. Check of his information through GCIC showed that he, like I said, is unlicensed and has, I believe, some suspensions.
Okay. With respect to the initial alert, was the defendant blue lighted?
So initially, no, on the highway, no, he wasn't blue lighted. But when we got to the neighborhood near 3187 Cascade Road, that's when Officer Griffey activated his marked patrol vehicle's lights and sirens.
And
that's when he fled.
Okay. Putting the public at risk of harm?
Correct. I could only visually estimate the speeds he was going. But in the residential neighborhood such as that, speed limits are 15 miles per hour, and he was going well over that.
Well over that, okay. When you initially encountered this defendant, what happened next? Did you, or what did you do next?
Yes, after I had him in custody, like I said, we determined his identity. He gave me the false name and date of birth. I then conducted an inventory of the stolen truck. Inside were several open packages with names and labels that did not belong to Mr. Haynes. The packages belonged to 14 separate victims. Some of them had multiple packages. I also located a screwdriver on the passenger side floorboard, along with a whole bunch of mail that appeared to have fallen down during the accident, the extremely rough accident. A check in Mr. Haynes's, like I said, information through GCIC not only showed that he was unlicensed, but also that he had multiple warrants out of 5 jurisdictions, one of them including APD for mail theft under case number 21243-1845. I read Mr. Haynes his Miranda rights. He agreed to speak to me without a lawyer. During our discussion, he explained to me that he received the Silverado truck from a male, Imani Saucier, E-M-A-N-I, first name, last name Saucier, S-A-U-C-I-E-R. Mr. Haynes explained to me that he had met Mr. Saucier only a week prior and that he knew that Saucier's occupation was being a drug dealer. So he didn't actually have a job. Mr. Haynes also admitted to me that he thought that he did notice the packages inside of the truck, that he believed that he thought that it did look suspicious, and it compelled him to the point where he moved the majority of the packages to hide them behind the driver's seat. As far as when I talked to him about mail thefts, he explained to me that he was with some friends who did commit mail thefts recently. He never admitted to actually committing them. But it does show knowledge that he is aware of mail thefts. Based upon his statements of receiving a $44,000 car from a drug dealer he just met a week ago, I believe that should have alerted him to the stolen status of the truck. Furthermore, the packages on the inside, he admitted were suspicious, and once again, should have shown that. As far as how I determined the screwdriver was a burglary tool, based upon his previous warrant of mail theft, the fact that stealing mail, these suspects are using screwdrivers to open up and pry open these mailboxes. In the presence of the mail inside, I determined that he possessed that screwdriver with the intent to possibly commit burglaries.
Do you see the person in the courtroom who has identified as a suspect?
If I can remove your mask.
Thank you, Your Honor.
Yes, Mr. Haynes is sitting at the defendant's table with the blue jumpsuit. He's sitting to the right of the lady with the gray jacket and pink top.
All right, Your Honor, may the record reflect that the officer has identified the defendant, Dominique Haynes.
So noted.
Just a few more questions. Were there any decals or anything on the exterior of the truck?
So the U-Haul decals from the U-Haul truck had been crudely removed. So no, there were no decals from it.
All right. And the defendant, he saw officers approaching and fled?
Correct.
All right.
I think it would have been impossible to ignore the marked patrol vehicle's lights and sirens.
And on the freeway, Did he change lanes improperly? Did you see that?
Correct, multiple erratic lane changes.
Also, once you got into the residential neighborhood, was there any improper lane changing?
Yeah, so to pass my car, I guess he drove on the wrong side of the road, but yeah.
And you were post-certified on this date, October 30th, 2022.
Correct.
No further questions from the state at this time, Your Honor.
Cross?
Thank you, Your Honor. I like to come around to make eye contact. So in regards to Mr. Haynes' case, you mentioned that there was mail located inside of the vehicle. Do you know the names or the locations from which this mail came from?
I would have to read my report.
But it would be in your report?
Yes, I listed the names and the locations.
Okay. Do you know if Officer Ramsey's patrol vehicle has operating dash cam?
Yes.
Okay. And
I couldn't testify to it, but in order to go into patrol, officers are required to check, do vehicle inspections beforehand.
Mhm.
If there's anything wrong, then they would have to take the car out of service.
okay, same question for your patrol vehicle then,
Correct.
and same answer.
Yes.
Um,
Well, I can testify to mine. My dash cam was working at the time. Our video is saved on evidence.com.
And in regards to this tracking dart, when you conduct these vehicle checks, do you also check the mechanism related to deploying these tracking darts?
I don't think I understand.
Well, I guess how is this tracking dart deployed from your vehicle onto a vehicle you're suspicious about?
It's like a hydraulic. It just shoots it out.
Okay. So before you go on patrol, is that something that you would check before getting into your vehicle going on patrol?
No. Typically, I mean, if it works, it works. If it doesn't, it doesn't.
Okay, so you wouldn't know the last time this tracking dart or its deployment mechanism has been checked?
Yeah, we don't do regular maintenance like that. It's just, if it works, it works. If I deployed it and it didn't work with the tracking, then it just didn't work.
Have you made any contact with Mr. Saucier? I might be pronouncing that funny, Amani Saucier,
No.
the purported friend. Did you or anybody related to this investigation make contact with either the apartment complexes or the homeowners related to these stolen packages?
No, I just forwarded the reports to our theft division.
Okay. Was the screwdriver collected for evidence?
Correct.
Do you know if that has been submitted for any kind of fingerprint testing?
No.
When you say that that the truck had U-Haul decals, can you describe how you know that these had been removed?
Adhesive on the truck left over from removing them, the sticky portions of it. And the fact that, like I said, there's no decals on it, nothing that said U-Haul anymore. Only thing that remained was the original plate from U-Haul.
Okay. Just one moment, Your Honor. All right, I have nothing further. Thank you.
Just very briefly, Your Honor. After the defendant provided the false information, how did you verify it's true information?
I don't recall. I know when I was able to confirm his identity, when I pull up for Dominic Haynes, the photo from the DMV matched that of the suspect I saw.
So you matched it with a DMV photo?
Yeah,
And
I'm not sure if we fingerprinted him or what we did, but I do know we got the name Dominic Haynes, and the one I found on the DMV photo matched that of the suspect.
that you identified in court today?
Correct.
All right. Nothing further from the state, Your Honor.
All right, Ms. Correa?
No recross, Your Honor.
All right,
Just
just argument?
Yes, Your Honor.
This is the only case?
Yes.
You can be excused. Stay safe out there.
Thank you.
Keep your fingers in your mouth.
I will.
Dirty. Get sick. All right. Go ahead.
Yes, Your Honor. We ask that you find probable cause on all charges, respected theft by receiving stolen property. We'll submit that the defendant should have known that the stolen property, that the Chevy Silverado was stolen property based on receiving it from Imani Saucier, the stolen items inside of it. All of this based on the officer's testimony with respect to the possession of tools for commission of a crime. As the officer's testimony established, the screwdrivers are regularly used in mail burglary incidences, and there was starts that were passed and erratic driving described by the officer that placed the public at a risk of harm. So we ask that you find probable cause for all 3 felonies and all charges. Nothing further from the state.
All right, Ms. Correa?
Thank you, Your Honor. In regards to the theft by receiving stolen property, my argument is that regardless of what Mr. Imani Saucier may be employed by doing or not employed by doing, I don't believe that that is sufficient for Mr. Haynes to believe that this car had been stolen. Friends frequently do borrow cars from one another. So I do not believe that there is a reason why Mr. Haynes knew or should have known that Mr. Imani Saucier may have acquired this vehicle through unlawful means. Furthermore, while screwdrivers may be used as tools for the commission of a crime, I also don't think it is unreasonable or unexpected for a screwdriver to be found in a car, because screwdrivers are used often in car and vehicle maintenance. I myself keep tools in my car just in the off chance I should run into some kind of vehicle trouble. I submit on the remaining charges, Your Honor.
All right. I find probable cause on each of the charges. Theft by receiving stolen property, possession of tools for a crime, fleeing, attempting to elude, reckless driving, speeding, driving with license suspended or revoked, giving false name, and failure to maintain lane. We'll take up bond. He's been in custody 87 days without indictment. Right now, there is a $99,000 split bond with no bond on theft by receiving stolen property, possession of tools for a crime, fleeing, attempting to elude. Pre-trial.
Mr. Hayes has 4 prior arrests. He appears to have an open case in Jonesboro for fleeing and eluding purchase, manufacturing, sale of marijuana, 2 counts. He also appears to have 4 holds in 4 jurisdictions. 1 is for escape in Jonesboro. 1 is for failure to appear, disappear. In Sandy Springs. 1 is for FTA in Fayetteville, and 1 is for fraud in Marietta. Nothing further.
All right. Go ahead, Ms. Correa.
Thank you, Your Honor. Mr. Haynes has resided in Georgia since 2003. The address listed in Odyssey and on his pretrial report is his good address out of Stone Mountain, 30083. That is where he resides with his mother. At the time of his arrest, he was gainfully employed with GK Entertainment. He has been employed with them since 2015 as an entertainment manager. I do confirm that he does have these holds. Given that he is now approaching these 90 days, I am asking Your Honor to go ahead and set a bond on these charges, so that way Mr. Haynes and his mother can make a decision as to whether or not he will move on to another jurisdiction to handle those pending matters before he comes back to Fulton County to answer for these charges. Either way, as you did note, the misdemeanor offenses are currently at a $9,000 bond. I'm asking Your Honor to set bond not to exceed $10,000. So that way he may go onto these holds and a grand jury warrant could then bring him back once Fulton County is prepared to move forward on this case.
All right,
Thank you.
What says the state?
Yes, Judge. We'll ask that the current $9,000 good bond already in place remain. We will submit a $5,000 good bond on the reckless driving, $1,000 on all the other driving misdemeanors is reasonable and fair. With respect to the felonies, in Ayala, we'll submit there is danger posed to other drivers on the road, the property of U-Haul, significant risk of reoffending, given the nature of the criminal history with multiple holds in open cases, as well as a significant risk of fleeing or not returning to this jurisdiction to face the charges, given an FTA and just the nature of these charges. So we'll ask for nothing lower than $15,000 good on each of the 3 felonies, particularly fleeing or attempting to elude a police officer. Nothing further from the state.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 626 DeKalb Avenue Southwest. That's West Inman Lofts. No further contact with anyone at Life Stance Health and Mariko, Mariko Perkins. No further contact. Imani, EMANI, Saucier, SAUCIER. Stay away from all U-Haul places. Looks like this was a U-Haul truck. Stay away from all U-Haul rental places and U-Haul trucks. If you have you can have an ankle monitor paid for by the county with a 24-hour curfew, sir, except for court, lawyer, medical. You can also leave for employment as long as you provide proof of employment, name of your employer, a schedule, and the exact location you'll be working. You'll have to let that be known to the ankle monitoring company and to Ms. Correa so she can let the state know. You'll have 48 hours to have that ankle monitor placed on your ankle. Seems you have a few holes. If you don't do that, your bond will be revoked and you'll sit in Rice Street. So I'll do 5 on theft by receiving stolen property, 5 on possession of tools for a crime, 10 on fleeing and attempting to elude. The reckless driving is already at 5, speeding at 1, driving with suspended license or revoked at 1, giving false information on law enforcement officer 1, failure to maintain lane 1, and also no driving until you have a valid license. Best of luck to you, sir.
Thank you, Your Honor.
Who's next?
We can go position 1 or 17. We're still waiting on position 9. I think I have another officer. Oh, Pat, how's it going? Which one do I have?
Your Honor,
Yes,
Oh, yeah, that's position.
yes, Mr. Adams.
You can have a seat.
yeah, thank you. Good morning. Sorry to interrupt. I'm just checking to see if my client is on today's calendar.
What's your client's name?
Fernando Williams.
Yes, sir. Did you do an entry of appearance? Because it's got Miss Pinto.
I beg your pardon now?
It has Miss Pinto assigned. Well, Miss Cole, Miss Pinto's handling it. Have you done an entry of appearance?
I thought I had, but maybe not. I can check it out.
All right.
All
What's
right,
the
let me answer another court call and I'll come back. Okay, is that okay with the court?
All right, that's good.
Okay, thank you, Your Honor.
What's the name of the case? Mumford.
17.
All right, Mr. Lang. So we just got the officer here for one of his cases, right?
Yes, that's correct.
All right. Officer, raise your right hand. You swear firm testimony about to give is the truth, whole truth, nothing but the truth?
I do swear.
All right, you can have a seat. We'll get Mr. Mumford up here.
Norwood, which case number this position 17?
It's on the calendar.
This one
Your
is
Honor, yeah.
17, it's the one ending in 3707.
Thank you, Your Honor.
Okay.
I don't have the calendar with me. That's why I was asking.
Oh, I see what you got you. And you know what, when I ordered them, I thought it was the mint.
All right.
Mr. Lang, you want to go ahead and take up on bond on this one also?
Yeah, Your Honor, we might as well.
All right.
Wait, no, come on. We got 1, 8, and 9 here. 8 was previously not here, now they are here. So. Y'all both together, look at you, and then y'all go like back to back. We're waiting on the.
Right now, it's already
attorney
got
to come
a
back down.
$5,500 good bond. That was in November. All right, this is position, well, it's different on different counters. Anyway, it's 22 CP 213707, Tracy Mumford. Been in 81 days without indictment right now. He does have a $5,500 good bond on BGCSA purchase or have control of Schedule 1 or 2 and drugs not in original container. Bossett will take up bond after this. Go ahead. And the officer has been previously sworn. Go ahead.
Good morning, Officer Ramsager. Thank you for being here. Could you please introduce yourself to the court? Where are you employed?
I'm Officer Ramsey. I'm currently employed with the City of Roswell Police Department.
How long have you been employed there?
Approximately 1 year, 10 months.
What are your duties with your current agency?
I'm currently assigned to the Uniform Patrol Division. It's our job to go out and detect and prevent crimes and respond to calls for service.
All right. So it's 911 calls or what?
911 calls, non-emergency calls, citizen contacts, anything people call the police department for.
Do you have any prior law enforcement experience?
I do not know.
Are you post-certified?
Yes, I am.
Were you post-certified on the date of this incident, October 16th, 2022?
Yes, I was.
All right. Can you tell the court about the incident that occurred on October 16th, 2022? How did your investigation of Tracy Mumford begin?
On October 16, 2022, at approximately 22:10 hours, I was on patrol in the area of Old Alabama Road and Old Alabama Road connector. There was a silver Honda, I believe Civic in front of me. I ran the license plate on that vehicle. It came back to a silver Honda Civic to a Tracy Mumford. The GCIC return showed that he had an active warrant for his arrest out of Alpharetta, Georgia. I pulled up the driver's license photo that was attached to the GCIC return. I was able to see he was approximately black male with short black hair. I was able to see he leaned over in the car when I was patrolling behind him and he had no tint in the back window. So I was able to get a clear view of the back of his head and I could see he was a black male with the short black hair, very consistent with his driver's license photo. And based on those factors, I stopped the vehicle. I approached the vehicle, asked him what his name was and if the vehicle was registered to him. He identified himself as Tracy and said that the vehicle was his. He provided me with a driver's license. Using the driver's license number he provided me with, I ran it through radio dispatch and they did confirm he had a warrant. At which point I requested an Alpharetta Canine officer to respond to the scene. And while we were waiting for the Alpharetta Canine officer to respond, radio dispatch informed me that the warrant out of Alpharetta was valid and Alpharetta did wish to place a hold. Shortly after that, I placed him into custody and searched him incident to the arrest. And while I was searching him in his front left pocket, I discovered 2 pills, which Mr. Mumford told me were Viagra. I was able to independently verify they were Viagra as they were stamped with Teva 5342, which is a sildenafil citrate dangerous drug. After placing him into custody, an Alpharetta officer arrived on scene. It was Alpharetta Canine Officer Ritchie. He conducted a sniff of the vehicle and informed me that there was that the dog alerted for narcotics within the vehicle. So I began to search the vehicle. Within the trunk, I located a gray duffel style bag. Inside that bag, there was mail with Tracy Mumford's name on there. And further in the bag, there was a black toiletries bag with personal items, I believe shampoo or items like that. And in there was a small baggie containing a white rock, very small white rock. Appeared to be crack cocaine using a field
field drug identification kit, which my sergeant provided me with. I wiped the rock with the wipe in the kit, and the rock and the wipe immediately turned bright blue, which was a presumptive identification for cocaine.
Right. Is 10-5-95 Old Alabama Road connector where you encountered this vehicle is that the incident location?
Yes.
Is that address in Fulton County?
Yes, it is.
So this incident took place completely in Fulton County?
Yes, it did.
Okay. With respect to the roadside substance test that you used to identify the substance, do you have training in using that?
I do not know.
Okay. But it's a regular part of your duties?
Yes.
Field test substances?
Yes, and my sergeant was with me at the time, who is experienced in drugs and narcotics, and he was able to walk me through the process.
So you were, and then the process concluded presumptively that it was cocaine?
Correct, yes.
What form was the cocaine?
It was just a very small, white, compact rock.
Okay. And with respect to the substance that you found that you were able to identify prior to the K9, how did you come to that conclusion?
He told me it was Viagra when I removed it from his pocket. And then additionally, with the marking stamped on the pill, I was able to use online resources. I believe it was the online pill identification Bible to identify it as sildenafil citrate.
But there was no original packaging for that?
No, he did not have the original packaging on his person or in the vehicle for that at all.
Did he have a prescription for it, to your knowledge?
I'm not aware of any prescription he had.
Okay. And there was already a warrant out of Alpharetta based on your dispatch?
Correct, yes.
Okay. Do you see the person in the courtroom today that you identified as a suspect? You can stand and describe where he or she is sitting, where he or she is sitting, and what he or she is wearing for the court?
He's sitting at the defendant's table wearing a blue jumpsuit with short black hair and a gray beard and a black mask.
All right. Your Honor, may the record reflect that the officer has identified the defendant, Tracy Munford.
Noted.
All right. You ran the license plate. At what point did you run a license plate test?
I'm sorry?
At what point did you run your license plate test on October 16th?
In regards to where I was?
Yeah.
I was on Old Alabama Road. We were approaching Old Alabama Road connector. We were heading westbound, and then he turned north on Old Alabama Road connector, at which point I activated my emergency blue lights and he stopped for me at the incident address.
It was based on running the license plate. There was no underlying traffic offense?
No underlying traffic offense, no, sir. Just going out and running plates that evening.
Which is a regular part of your duties?
Absolutely, yeah. Looking for no insurance, suspended registration, stolen vehicles, items like that.
And you were pro certified on October 16, 2022?
Yes, I was.
No further questions for this witness at this time, Your Honor.
Cross, Mr. Lang?
Yes, Your Honor. Good morning, Officer Ramsager?
Yes.
Sager or Sager?
Ramsager.
Ramsager, okay. Just want to make sure I pronounce it right. My name is Attorney Lang. I represent Mr. Munford. I'm going to ask you some questions and follow up on some of the questions you were asked by ADA Norwood.
Okay.
I want to start, so you said that the Viagra you discovered, first off, it was generic Viagra, correct? It was not, I guess, branded. It didn't have Viagra stamped in the pill?
No, there's no Viagra stamped on the pill.
Okay. You said it was not in the original container, correct?
Correct.
What is the original container for the product you found?
I do not know. I believe it would be in just a standard orange pill container with a white cap.
Are you familiar with any online services people use which send them pills in the mail?
I'm not, no.
Okay, you haven't seen any of the commercials for Hims or Keeps or any of those products?
I don't watch TV.
Okay. Why did you request a canine unit on scene?
I had seen his warrant was for a previous drug offense, and while we were waiting for the warrant to be confirmed and nothing else to do, figured we'd have a canine come and respond.
But in viewing him or the vehicle itself, you had no reason to believe he had any narcotics in the vehicle other than his history?
No.
You said the description you attributed to the license plate photo you saw was black male with short black hair?
Correct.
And that at some point you saw Mr. Munford driving the vehicle, turn his head and were able to match the description that way.
He had not turned his head. He had more leaned over. I saw the back of his head and the hair matched almost exactly what I'd seen in the driver's license photo, as well as the skin color.
So you saw the back of the head of a black male with short black hair,
Yes,
and that matched the driver's license of the front of the face of a black male you saw.
correct.
Okay. You mentioned that, was this your first time using a field training kit, or you just not been trained in them, but had used them before?
It was my first time using that specific type of kit. I've used the ones where you break the glass and shake it up before. That was my first time using the wipe style kit.
You said you work with Roswell Police, correct?
Correct.
Does Roswell Police still use these field tests out in the field to this day?
To the best of my knowledge, yes.
Okay. Have you heard from any of your colleagues in other jurisdictions whether they still use field tests in those jurisdictions?
I don't have any colleagues in other jurisdictions.
Okay. One moment, Your Honor. No further questions at this time, Your Honor.
Redirect.
No redirect, Your Honor.
All right. That's it, just argument?
Yes, Your Honor.
Yes,
All right.
Judge.
This officer, yeah, is this your only case?
Yes.
Yes. Well, we ask that he be excused.
All right. Stay healthy and safe out there.
Thank you. Take care.
All right, go ahead with argument.
State submits on evidence subject to rebuttal.
All right, Mr. Lang.
Your Honor, I'm asking the court not to find probable cause on the drugs not in original container. Primarily on the fact that we did not hear what the original container of these products should have been. You know, these products don't necessarily have to have come from a CVS pharmacy and been in an orange pill bottle. There are multiple services online, especially when it comes to erectile dysfunction medications that send things through the mail in different forms of packaging. We heard not only what were these pills in his pocket, we heard they were in his pocket, but we don't know if they were loose in a plastic baggie, in a dime bag. We don't know what they were in, and we don't know what they should have been in. We don't know what the original container is. So at this point, it wouldn't be proper to hold him on not having them in the original container when we can't tell him what container he should have had them in.
All right.
And we'll submit on the cocaine.
What says the state?
Says a dangerous substance that was not in any container. Based on not being in any container, we would submit that there is probable cause for the misdemeanor drugs not in original container. Nothing further from the state.
I mean, looks like he, and I say this with complete respect, sir, it looks like he might be an older gentleman. I mean, my dad would get in trouble for throwing his prescription pill in his pocket to take it later. So I'm just not going to find probable cause on drugs not in original container because I don't know if it was supposed to be a prescription bottle and he didn't really say, or one of those like Monday through Friday bottles, but I'll find probable cause on the cocaine. Let's see. Go ahead, trial.
In regards to Monford, two other open cases in Fulton, 22 CP 213706, meth, drug-related objects, 22 CP 213707, VGCSA 1 or 2, drug-related objects, multi-state offender arrests, 3 in New York, 3 in Virginia, 1 in Arkansas, 4 in Georgia. But last conviction was in 94. That's why he initially got a pretrial bond on this case, but it was surrendered due to he's in custody on a new case. Nothing further.
All right. Go ahead, Mr. Lang.
Yeah, just to clarify, this is case number ending in 707.
Yes, sir.
Okay.
707.
So this case does currently have a bond. This case now, with Your Honor dismissing that one charge for lack of probable cause, has a $5,000 good bond on it. Mr. Munford is 38 years old. He has 2 children, both of whom live in South Carolina. He graduated from UTSA with a culinary degree. He's currently retired, collecting disability. He's lived in Georgia for the last 6, or at this point, 7 years of his life. I'm not sure if his address has been updated on the file or not. Just in case, I'll double check and file change of address today, but he's going to be living in Kennesaw. Looking at what we have, and especially with having 3 cases, from what I have written of his criminal history and from what we heard from pretrial, 11 cycles at essentially 60 years old, that's not a routine pattern. That's not a large number, picking up 2, 3, 4 cycles every single year. So he's not a danger to the community. He's not a massive risk of reoffense. Based on that information, I'm asking the court to cut the current bond to $2,000 good.
All right, what says the state?
Lane, sorry to interrupt. Judge, from the calendar, this is 7:35. This is the one that the bond surrender was done on.
This is 7:07.
This is position 17 on the calendar.
Yes,
Yes,
it's 22 C.
17 or 2?
17.
17.
17. The numbers are all mixed up, but it's the one ending in 3707.
This isn't the pretrial surrender
This is
one.
not the pretrial one.
Right.
Okay.
All right, what says the state?
Yes, Your Honor, we will submit there is danger posed to the community with the possession of the substance here, as well as a significant risk of reoffending, given the nature of the substance. We would submit a $5,000 good bond is reasonable and fair here. And we are concerned about those open cases in Fulton County. Believe it's in Your Honor's sound discretion, nothing further from the state.
All right, so here's what I'm going to do. No drugs unless prescribed, no alcohol, no weapons. Sorry, don't come back to Fulton County unless you're here for court or to see your lawyer. Stay out of Fulton County. Do you understand? All right, he said, yes, ma'am. Good for you. All right, I'm going to reduce it to $2,500. Best of luck to you, sir.
Your Honor, if I can very quickly, since he does have 2 other positions, does Your Honor want to do bond on those as well? Because I don't believe the officers are here, so they're likely going to get reset. Or do we want to just wait and handle that at the end of the
Does he
calendar?
have 2? One, is it one other one or 2
He
others?
would still have position 2 and position 16.
All right, so we'll go ahead and do bond on the other 2. Do you think they're coming?
Yes, I do. Yeah,
Okay,
I'm
then we
just
can
waiting
wait.
for updates from our investigator. I can inform the court once I have official updates that the officers aren't coming, but I
Nobody else is
assume-
here on Lane?
Then we can wait, Your Honor.
Okay.
Yeah.
All right, who's,
We can do 8 and 9 right now.
that's, right, is that William Gear?
Yeah, officer for position 9 was here. We can do his, and then we can do gear, or we
Right.
can do gear now.
Ricky Shine Foster, who's here? Oh, Miss Sampson. Miss Sampson, aren't you Ricky Shine? Okay, we'll do, Ricky Shin Foster first.
Yes.
And then we'll take care of the other one. All right, it's position 9. Raise your right hand for me. Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
I do.
All right, if you state your name and spell it for the court reporter. You
My name is
there you go.
my name is Tommy Ho, and it's spelled TOMMYHO.
All right, this is 22 CP 213327 Ricky Shin Foster. 98 days without indictment. Looks like there's already a $5,000 good bond as of October the 20th. Theft by shoplifting and possession of tools for the commission of a crime. Go ahead. What says the state?
The state calls Officer Tommy Ho. We appreciate you being here. Introduce yourself to the court. Where are you currently employed?
With the Atlanta Police Department,
How long have you been employed with the Atlanta Police Department?
coming up 6 years.
What are your duties with your current agency?
I'm currently assigned with the FOD Zone 2 Evening Watch. I currently are answering 911 calls and conducting enforcement on traffic.
Do you have prior law enforcement experience?
No.
Are you post-certified?
Yes.
Were you post-certified on the date of this incident, October 19, 2022?
Yes.
Can you tell the court about the incident that occurred on October 19, 2022? how did your investigation of Ricky Shin Foster begin?
So I responded to a shoplifter call over at Macy's located at 3393 Peachtree Road, which is at the Lenox Mall. When I got there, I met with one of the loss prevention officer who advised that they observed a black male, black hoodie, black backpack that was inside Macy's, basically using a wire cutter to cut off the alarm sensors off 4 Ralph Lauren polo shirts. And after he cut the alarm sensor, he would shove all 4 shirts inside his backpack for concealment. The suspect would then proceed to leave the store without paying for the merchandise. He passed all points of sale, and the total amount was $506. All was recorded on surveillance footage as well.
All right. Is 3393 Peachtree Road, is that address in Fulton?
Yes.
All right. And again, who called the police?
Brianna Mason.
And who is Brianna Mason? What does she do?
She's a loss prevention officer with Macy's.
And she advised that she observed, what did she advise?
She observed through surveillance footage, unknown black male with black hoodie and black backpack, later identified as Ricky Shin Foster.
And when you arrived, did you see Ricky Shin Foster on the scene?
Yes.
Did you take him into custody?
Yes.
How did you identify Mr. Shin Foster?
He provided me the name, and I was able to match the photo that he provided.
Do you see the person identified as a suspect in the courtroom today?
All right, if everybody can remove your mask.
Yes.
Can you describe where he or she is sitting and what he or she is wearing?
He is sitting right there besides the lady in gray. He's got a blue shirt on with long gray sleeves.
Thank you. Your Honor, may the record reflect that the officer has identified the defendant, Ricky Shin Foster.
Noted.
Just a few more questions. With respect to your arrival on the scene, did Mr. Shin Foster have anything on his person?
Yes, he had a wire cutter in person.
On his person, the wire cutter? Did he have anything else?
Along with his backpack.
What was inside of the backpack?
The 4 polo shirts that he initially concealed.
Okay. How much did those polo shirts cost?
They range from like $100, but the total came out to be $506.
Did Brianna Mason advise that total?
Yes.
Okay. Did you speak with anybody else?
No.
Okay. And Brianna Mason observed this on surveillance cameras.
Correct.
Then the suspect proceeded to conceal the clothes inside his backpack. And then what did he attempt to do? Did he attempt to do anything else after that?
Yeah, he proceeded to leave the store without paying for those merchandises.
Okay. Okay. When you observed the polo shirts, do they still have the price tags on them?
I do not believe so.
Can you describe the wire cutter?
They almost look like a set of pliers.
Okay. Okay. And again, the total value was what?
$506.
Okay. Did you observe the surveillance cameras?
I believe I showed her. I believe she showed me when he was leaving with the items and all that.
Okay. Okay. And you were post certified on October 19, 2000. I don't know how to respond to that.
Yeah, I think you've already asked if he was post certified, but
Oh, that was my last question. I just wanted to verify that he was post certified. Yeah. No further questions, Your Honor. You were post certified though?
Yes.
Okay. Yeah.
all right, Cross.
Good morning, I think it's morning. Yeah, good morning. So I heard you say the last name Mason. I didn't hear you say the first name for the loss prevention.
Brianna.
Can you spell that for you, please?
BRIANA.
Okay, and you mentioned that you got the total for the items from this Mason, correct?
Correct.
How did they provide you with the total?
I believe they printed out a sheet of paper with the items that were stolen.
And the items were returned back to the store?
Yes.
And you mentioned during your direct that you found the alleged suspect on scene?
Yes.
Where on scene?
He was in the loss prevention room detained until police came out.
Did he make any statements to you when you arrived? He as in Mr. Shin Foster?
I do, but I do not recall.
Okay. And it was a little fuzzy as to how you did the identification. Can you clarify how you did the identification?
So I initially got his information and all that stuff. And he gave me his brother's name. And came out that his brother had warrants. And it wasn't him. And then he gave me his true name, which is Ricky Shin Foster.
Did you, the surveillance that you mentioned you saw, did you get a copy of that?
A copy of what now?
Of the surveillance of the incident that you said?
Yes, they have that.
Who's they?
The loss prevention team.
Okay, so before you left the scene, you got a copy of it, is correct?
No, I did not.
Okay, was there somebody else that arrived on scene to get a copy of that surveillance?
No.
Okay, so you left, so
Brianna Mason has a copy.
okay. Did you have your body cam on when you watched the surveillance?
Yes, it's on, yeah.
You said it was on?
Yes.
You turned your body cam in already?
Yes.
One second, Your Honor.
Okay.
Nothing further.
All right, redirect.
No redirect, Your Honor.
All right, argument.
The state submits on the evidence subject to rebuttal. May our officer be excused?
Yeah. It's your only case, right?
Yes.
Okay, sure.
Question.
All right, we'll find probable cause on theft by shoplifting and possession of tools for a crime. Will be heard on bond. There's a $5,000 good bond already. Pre-trial.
In regards to Shin Foster, extensive arrest history, 15 in South Carolina, 15 in Georgia. Convictions, prior robbery, 2022, theft by shoplifting out of Clayton, still on probation, 24 months, probation, 24 months confinement. Multiple shoplifting, 2016, 18, 16, 17, 19, 19, 20, FTA in 22, violation of probation in 23. Nothing further.
All right, go ahead, Ms. Sampson.
Thank you, Your Honor. Mr. Shin Foster is 38 years old. He is residentially challenged. However, I received a acceptance letter to Sober Living America on January 19th, Your Honor. At this time, I'm asking for a UJR to a program hold for Sober Living America. Before he was arrested, he did receive his GED in 2004, and he was working as a car wash under a friend's car wash company before he was arrested. But within the past 2 months prior to his arrest, he was unemployed, Your Honor. And he does have 2 children to provide for, ages 6 and 8.
All right, what says the state?
Yes, Judge, with respect to Ayala, we'll submit there is danger posed to the property of Macy's in other businesses in that Peachtree Road area, or the incident address. We would submit there's a significant risk of reoffending, given the open probation particularly, and the nature of the criminal history We understand the defendant is residentially challenged. We also understand that that poses a significant risk of not returning to this jurisdiction to face the charges. The state would hope that this defendant would seek, treatment for any substance use disorders. And we would have no objection to a sober living America if it can be confirmed that there is a bed for this defendant should he be released there. But we'll leave this matter in your hands.
And if I may, Your Honor, to answer the question.
Sure.
Yes, I received confirmation yesterday afternoon that a transport for January 27th would be accepted by the sober living. So if Your Honor gives him a UJR to the program, I can get that transport order as soon as I walk out to, as soon as I get to my office.
And where will he be living?
At Sober Living America, Your Honor, so there are certain areas where they have, their address is secluded, so they don't make it public as to what the address is. I can put it in the transport order, though. It will definitely be in the transport order.
Is it gonna be in Fulton County?
Yes, Your Honor. That is my understanding. Sober Living is located in Atlanta, so I'm assuming it will also be in Atlanta.
All right, what says the state?
Again, the state is concerned about that risk of not returning to this jurisdiction to face the charges, as well as the risk of reoffending. We would ask for a stay away from 3393 Peachtree Road, Atlanta as well.
We're trying to stay away, Your Honor.
Okay, here we'll do, stay away from all Macy's, stay away from Lenox Mall. At the 3393 Peachtree Road in Atlanta, Georgia. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the ORCA project with the 24-hour curfew, court, lawyer, medical, and participating in any programs that Ms. Sampson gets you into. So what we'll do is we'll reduce it to $1,500 each count, or UJR to the program only. So if the program, for some reason he can't get to the program, they won't pick him up, then you've got a $3,000 good bond.
Thank you, Your Honor.
Best of luck to you, sir.
Is that, is the litigation manager on? Because I just want to, so if you split it like that, is the jail going to acknowledge that? Because I've heard that they don't, so.
Well, they've done it before. It's either UJR to that program. If they don't come get him, then he has then he has $1,500 on each to come get him.
That was UJR pretrial, Judge?
No, it's UJR through that program, Sober Living. So the way you put it on there is there's $1,500 per count. Unless it's either that, he can make that, or he can be released to that program.
Okay, UJR to the.
That way, if the program wants to come get him, he can get out. But if they don't, he still has the opportunity to make the good bond.
And what was the name of that program?
Sober Living.
Sober Living America.
Sober Living America. Thank you.
Thank you.
All right. Thank you, sir. Best of luck to you. All right. So we got, wait, there was another one that was on for, was it William Gear for Miss Indigo?
Yeah, we got Officer.
Oh, you're here for Gear, right?
Yeah, John Noel was here. Did you want to go? Did you need to go right now? Or? Oh, while we have Sampson down here, she might have to go somewhere else, so we can go with your case.
Well, I think this is the last case for Miss Sampson, right? Gear? Yeah, so do William Gear.
Yeah.
Yes.
Position 8,
Thank
Officer
you.
Petkoff. Appreciate you being here. I had
Found that one.
a note that, you feeling all right?
Yep.
All right.
All right, if you raise your right hand, you swear a firm testimony you're about to give is the truth, whole truth, nothing but the truth?
I do.
All right, state your name, spell it for the court reporter, please.
My name is Officer Miroslav Petkov with the Atlanta Police Department. First name is spelled Miroslav. The last name is Petkov.
All right, you stand by, they'll bring him out here.
And Your Honor, when he's brought out, if I can just get 30 seconds to just check with him on something.
Okay.
I'm ready, Your Honor. Thank you so much.
All right. This is position 8 or whichever on there, 22 CP 213323, William Gear, 98 days without indictment, aggravated assault, possession of a knife or a firearm during the commission of or attempt to commit certain felonies, theft by shoplifting, misdemeanor. All right, go ahead.
Thank you, Your Honor. Good morning, Officer Petkov. We appreciate you being here. Could you introduce yourself to the court? Where are you currently employed?
Yes, sir. I'm employed in Zone 2, Atlanta Police Department.
How long have you been employed there?
Approximately 1.5 years, coming up to 2 years.
What are your duties with your current agency?
Answering 911 calls, proactive enforcement.
Do you have any prior law enforcement experience?
No, sir.
Are you post-certified?
I am.
Were you post-certified on October 18th, 2022, the date of this incident?
Yes.
Can you tell the court about the incident that occurred on October 18th, 2022? How did your investigation of William Gear begin?
Okay. So we received a 911 call for service in regards to a shoplifter in progress at 2525 Piedmont Road, which is a Home Depot. As I was en route to that location, since it is in my beat, the call got upgraded to a dispute with a weapon. Upon arrival to the scene, I met with the victim, who is Darius Mitchell, the loss prevention officer at Home Depot. Mr. Mitchell stated that a white male with a long scruffy beard, long hair, attempted to shoplift from Home Depot, walked out with a hatchet or an axe, and he attempted to apprehend the suspect to just acquire the property back. The suspect dropped a long chain with a knife attached to it and began swinging it violently while walking forward towards the victim, stating that he was going to kill him. The victim obviously backed off, at which point he called 911, and the suspect ran towards Sidney Marcus from Piedmont. As I gathered that information, I gave a BOLO, which is a lookout over the radio. Other responding units were able to see the suspect running down Sidney Marcus past Georgia 400 southbound. I drove over there to make contact with him. I was still able to observe him running. Had several officers behind him giving him commands to stop running. He came up to a fenced area where he stopped. He was held at gunpoint because he was still holding the long chain with the knife attached, and we could see the hatchet from his backpack, which was open. So he was safely placed in custody without incident, taken back to the incident location, where he was brought out of the car, out of handcuffs, so a show-up could be conducted, at which time the victim positively identified him as the suspect. Search incident to arrest. We were able to recover the stolen hatchet, which has a value of about $50. If I remember my report correctly, we were able to return that back to Home Depot. There was also another loss prevention officer on scene who witnessed the incident. He filled out a witness statement form. The victim filled out a victim form, and there is surveillance video footage that Home Depot has saved.
All right. Thank you. It's 2525 Piedmont Road. Is that in Fulton County?
Yes.
Is Sidney Marcus, the intersection with Georgia 400, is that also in Fulton County?
Yes.
Okay. With respect to the 911 call, who called 911?
The victim, Darius Mitchell.
And he was a loss prevention officer. Were there any other loss prevention officers involved?
Yes, Mr. Sion. It's in my report. I can't recall his first name.
All right. And did Mr. Mitchell explain the incident to you?
Yes.
Was there any surveillance?
Yes.
And then so what does the surveillance show?
I did not watch the surveillance. He did say that the video shows him concealing the hatchet inside his backpack, walking out of the store. At which point Mr. Mitchell walks up to him to try to acquire the property back. He walked past all points of sales, obviously. At which time he began swinging the chain with the knife attached while walking towards the victim and making a threatening statement saying that he's going to kill him.
Okay, and were there any witnesses to the statement, I'm going to kill him, I'll kill you?
Yes, the other loss prevention officer, Mr. Sion.
Okay, and all of this was observed on surveillance,
I did not observe it.
but Mr. Mitchell
Yes.
explained that's what
Yes.
was on the
I'm
surveillance to
not
you.
sure if other officers on the scene observed it.
Okay, can you describe the knife?
Yes, it's a long chain, maybe about 3 feet. I turned it into evidence. The knife is probably an 8 to 10 inch blade attached to the chain. And he, when we encountered him, he had it wrapped around his hand.
Did the knife hit Mr. Mitchell?
No.
Could it have hit Mr. Mitchell?
That
Objection, Your Honor. That is beyond speculation.
Rephrase.
Well, oh yeah, I'll rephrase, Your Honor. Based on Mr. Mitchell's explanation of the incident to you, was there any danger posed to Mr. Mitchell?
Yes, Mr. Mitchell felt that his life was in danger and he was in close capacity to receive a violent injury, which could have caused great bodily damage or possibly death. And he wrote that in his statement form as well as the other loss prevention officer.
Okay. And you identified this suspect based on the bolo?
No, the suspect provided his name. I was able to run it through GCIC, pulled up the DMV picture, and it matched to the suspect.
Yeah, and you took him back to Mr. Mitchell for a show up?
Yes.
And Mr. Mitchell positively identified this defendant?
Yes.
Can you see the suspect? Do you see the person in the courtroom who has identified as a suspect today?
Everybody remove their mask.
Can you describe where he or she is sitting and what he or she is wearing?
Yes, Mr. Gear is sitting at the defense table next to a lady with a gray sweater and a black shirt, wearing a blue jumpsuit with gray sleeves.
Let the record reflect, Your Honor, that the officer has identified the defendant, William Gear.
All right, so noted.
All right. With respect to the hatchet, did Mr. Mitchell observe this defendant in the store with the hatchet?
Yes, through surveillance cameras.
And then what did Mr. Mitchell do next?
As the suspect was walking past all points of sales, he exited the store. That's when Mr. Mitchell attempted to apprehend him or speak to him in regards to acquiring their property back.
All right. And then you were post-certified on this date, October 18, 2022.
Yes, sir.
All right. No further questions from the state at this time.
All right, Cross.
Good morning.
Good morning.
I heard you say that we received 911 call. Who was we?
Patrol officers at the time.
So that's you and who else, specifically their names?
Officer Thurman was there. Officer Jones was there.
And so I'm sorry, remind me of your last name.
Petkov,
Spell it, please.
Petkov.
Thank you. And the person who called 911, you said it was Darius Mitchell, is Darius?
Yes.
Okay. And I do recall you saying that the shoplifting was caught on surveillance, correct?
Yes.
Was the alleged aggravated assault caught on surveillance?
Mr. Mitchell said that it is, yes.
Did you see the theft by shoplifting caught on surveillance?
I did not. I'm not, and I don't recall if any of the other officers watched the surveillance.
Okay. Did you see the aggravated assault that was caught on surveillance?
No.
Okay.
Was there audio of any of the aggravated assault caught on, was it caught on audio recording at all?
No.
Okay. Did the suspect make any statements to you other than his name?
I don't recall.
You said there were 2 loss prevention officers?
Yes.
Okay, what is the name of the other one? I have Darius Mitchell.
I'd have to look at my report. I believe his last name was Cyan.
And would you have to know how to spell that?
I believe CYAN.
You said that Mr. William was safely placed in custody?
Yes, after a brief foot pursuit.
Okay, was he placed in your patrol call?
Yes.
Okay. And your camera in the car was on, correct?
Yes.
1 second, Your Honor.
Okay.
Did the loss prevention officers, are those deputized officers or security guards?
Security.
Security guards. Do they have guns?
No.
Do they have weapons at all?
No.
And did you personally check to see if they had weapons?
No.
Okay. Did you see anybody actually check to see if they had weapons?
The security guards?
Yeah.
No.
Okay. And other than these loss prevention officers, were there actually other witnesses to the alleged aggravated assault?
Not that I recall.
Okay, was the alleged aggravated assault, did it happen outside or inside the store?
Outside?
Okay, so in the open parking lot?
Yes. With Home Depot's parking lot happened right in front of the front door.
Okay, were there cameras right there in the front?
I believe so.
Okay, so that means it should have been caught on surveillance?
Yes.
Okay. Nothing further.
All right, redirect.
Just very briefly, Officer Petkoff, if you were to look at the warrant, would that refresh your memory about as to what the other loss prevention officer's name was?
Yes.
Your Honor, may I approach with a copy of the warrant just so he can put the other loss prevention officer's name on the record?
Sure.
All right. Permission to move around.
So the second loss prevention officer is Mr. Jason Sine, which is CYNE. Thanks.
And Mr. Sine witnessed the whole altercation?
Yes, including the shoplifting.
All right. And with respect to when you took the suspect into custody, you said multiple officers gave this defendant lawful orders to stop running. And what did the defendant do?
The defendant reached a fence post, at which point he was surrounded by officers. And we did have our guns drawn because we observed that he was still holding the long metal chain attached with a knife.
Okay. But he was given the command to run and kept running towards this area?
Yes, he was given multiple verbal commands to stop running.
Okay. Nothing further from the state, Your Honor.
Anything else, Ms. Sampson?
No, Your Honor.
Okay. This your only case?
Yes, ma'am.
May Officer be excused?
Absolutely. Stay
Thank
safe. All right, go ahead with the argument.
Yes, Judge. I'll make sure he gets his jacket real quick. Appreciate you. Yes, Judge, we ask that you find probable cause on all three counts here based on the officer's testimony. And if inclined, we would ask that you add a terroristic threats charge based on officer's testimony that this defendant stated to officer the loss prevention officer Mitchell that he was going to kill him, or he threatened him, stating that he was going to kill you. This was witnessed by the other loss prevention officer, Jason Sign. And if Your Honor is so inclined, we ask that you add a misdemeanor willful obstruction of law enforcement officer based on the defendant running when given orders to stop running. Nothing further from the state.
All right, Ms. Sampson.
I believe in the court's discretion, Your Honor.
All right, I'll find probable cause on terroristic threats, which will be a new charge, ag assault, possession of firearm or knife during the commission of certain felonies, and theft by shoplifting. And it's been in jail 98 days without indictment. And let's see. Right now, there's an $11,000 good bond as of October the 20th. Pre-trial.
In regards to Mr. Greer. Hold on. Greer. Okay, my computer won't act before. Greer. Took a burglary in the first degree in 2014, 3 years. May have it. Nope, that's too old.
Wait, you're saying gear, right? Gear.
Yeah, that. I don't know why I'm saying Greer. 2 arrests in Kentucky, 4 in Georgia. The first offender plea. Last arrest was in 2022 in Brookhaven for obstruction. Nothing further.
All right, Ms. Sampson, does he still live in Fulton County?
I have the address of.
Sandy Springs?
Yes. That's the
Okay.
address that I have.
All right, go ahead.
Yes, Your Honor, for mailing purposes,
It's okay.
for mailing purposes, I have it for Sandy Springs. However, he is, that's where his mother resides. However, he is residentially challenged at this time. So having him not allowed in Fulton County would literally be, I don't even know how he would actually get out of Fulton County without having a extreme issue. But he's 8-year-old son as well, living in Georgia, Your Honor. He's been unemployed for the past 6 months. Prior to being unemployed, he was doing construction work for 4 years for Balfour Backety Company, Your Honor. At this time, I'm asking that the bond, if you're not inclined to reducing the bond of 11,000, I'm asking for the bond to just stay as is at 11,000 total with the new charges added.
All right, what says the state?
Yes, Your Honor. With respect to Ayala, we'll submit that this defendant poses a significant danger to property in the community, particularly the Home Depot here. We'll ask for no further contact, stay away from all Home Depots, no further contact with Darius Mitchell. That was requested by him per our victim witness advocate. With respect to the rest of Ayala, we'll submit there is a significant risk of reoffending pending trial. Given the nature of the history, the state is concerned about the multi-state history here. And given that this defendant is residentially challenged, we'll submit there is a risk of not returning to this jurisdiction to face the charges. We'll ask that the $11,000 good bond remain, and we'll leave the terroristic threats bond amount in Your Honor's sound discretion.
And Your Honor, that will be a consent to the 11,000, leaving it as is.
I'm sorry.
And that will be consent to the 11,000, leaving it as is.
Okay, so I'll do, I'll leave it at 5 on ag assault, 5 on possession of a knife or a firearm during the commission of certain felonies, 1 on the misdemeanor shoplifting, and 5 on the terroristic threats. Stay away from 2525 Piedmont Avenue, with the Piedmont Road, Piedmont Avenue. Stay away from all Home Depot stores. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical, and work. You have to supply the name of your employer, the place you're working, the exact location, a schedule. You have to supply it to the ankle monitoring company and to your lawyer, who can then supply it to the state. No further contact with Davis Mitchell or Jason Syne, C-Y-N-E. And you have to provide an address where you will be staying, sir, at the jail before they let you out. So talk with your mom, talk with whoever, but you have to provide an address where you'll actually be living. Best of luck to you, sir.
That concludes my business, Your Honor. May I be excused?
Yes, ma'am.
Thank you.
I'm sorry, Judge. I have a quick question on that case. For the terroristic threats, was that 500?
Embry, I can't hear him, sir.
Was that 500 on the terroristic threat?
No, 5,000.
5,000. Okay, perfect. And then back to position 9 to discuss the UJR to the program. When they're released from to a program from the jail, they require additional information. So they would need the phone number of the program, the date, the defendant.
Right. She'll send an order once the program he's enrolled in the program. They'll have all that information on it.
Okay, perfect. So for now, for the bond order, it just needs to say UJR to the program or 1.5K if he isn't picked up.
Right.
Okay.
And she'll send, once he's elected, once he's into the program, they'll send an order to me and I'll sign it. It has all that information.
Perfect. Sounds good. Thank you.
Okay. What's your case there? Which case is yours?
Mr. Carl Bennett.
Position 1, yes. Or we have position, yeah, it might be a different position on the other count.
All right, Carl Bennett. Raise your right hand for me. Do you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, ma'am.
Okay. Have a seat. Just make sure that you speak up for the court reporter, state your name and spell it for the court reporter. No.
I'm Officer James G. Noel, James, first name, last name, JN-NOEL.
All right, stand by. All right, this is 22-CP-213231, Carl Bennett. 101 days without indictment, aggravated assault, and possession of drug-related objects. And looks like, it's a little slow, there is no bond as of October the 17th, so we'll take up bond. Go ahead, what says the state?
Thank you, Your Honor. The state calls Officer Jane Noel. Thank you for being here, Officer. Could you introduce yourself to the court? Where are you currently employed?
My name is James, Officer James G. Noel. Yeah, I'm working on Zone 5, Morning Watch, Section FOD, and I was a patrol officer.
All right. How long have you been employed with the Atlanta Police Department?
About 2 years.
2 years. How long have you been on a patrol officer?
About 2 years.
All right. What are your duties with your current agency?
Inside 911 call and preventing crime.
911 calls and what? I couldn't catch the last part. What was the last?
Preventing crime.
Okay, okay. Do you have any prior law enforcement experience?
No, sir.
All right. Are you post certified?
Yes, sir.
Were you post certified on October 16th, 2022?
Yes, sir, I do.
Can you tell the court about the incident that occurred on October 16th, 2022? How did your investigation of Carl Bennett begin?
Yes, sir. On October 16th, 2022, at approximately 03:2700 hours, I was dispatched to 186 Auburn Ave. About 2 males fighting in the street.
I apologize. Are you currently reading What is it that you're reading from?
Sorry?
Are you currently reading from the police report?
Yes, ma'am.
Okay. I object to reading the police report into the record.
So I ask that you not read from the police report. If you need to refresh your recollection, that's fine, but don't read from it, okay?
Oh, okay, okay. Yes, so upon my arrival, so I met with the victim, Mr. Boulerin Omar, and he said he was beaten by an individual, a black male, and so when he said he was beaten by a black male, and later it identified as Mr. Carl Bennett. So Mr. Carl Bennett wasn't on scene at the time I arrived on the scene. And the victim said he was in an argument with Mr. Bennett, and Mr. Bennett went behind him and hit him with a big stick multiple times. And also, Mr. Bennett threw a brick on his head, on his head, and caused a lump on his forehead. So when I asked him, where is Mr. Bennett? He said Mr. Bennett was staying in 2 blocks from the scene. So I went over there on Piedmont. I think it was 120 Piedmont, and I saw Mr. Bennett staying here, and he was wearing the same clothes that Mr. Boulerin told me, and I approached him and asked him if he was in fighting with Mr. Omar, and Mr. Omar was walking down to also and identify him to me, and I detained him. And during my investigation, they have camera at the intersection of Piedmont and Auburn, where the incident occurred. And when I'm watching the footage, I see Mr. Bennett run behind the victim, and he hit him with a big stick. And after, he ran again behind him with the brick in his hand and threw the brick and hit Mr. Boulerin on his head.
All right, thank you. Is 186 Auburn Avenue, is that in Fulton County?
Yes, sir.
Is 120 Piedmont, is that also in Fulton County?
Yes, sir.
All right. Just so to clear up a few things, who called 911?
The victim, Mr. Boulerin.
Mr. Lamont Boulerin?
Yes, sir.
Called 911?
Yes, sir.
And when you arrived on the scene, what did he say happened?
He said he got beaten by an individual, who is.
He got beaten by who?
Yeah, by Mr. Bennett.
Okay. Did he do anything first?
He said there wasn't an argument.
There's a verbal altercation.
Yeah, verbal altercation.
Do you know what the verbal?
In the parking deck at the intersection Piedmont in Auburn.
So what was the verbal altercation about?
The verbal altercation about a place, something. I think Mr. Bennett said he can coming in this place. He is his spot, stuff like that.
Okay. And as a result, what did Mr. Bennett do to Mr. Boulerin?
So Mr. Bennett, I think, so during the argument, so Mr. Bennett, I don't know, upset and went behind Mr. Boulogne and with a big stick. And when Mr. Boulogne crossed the street, he crossed the street behind him and hit him with the stick.
Okay. Was there, when you arrived on the scene, did you see any big stick?
I did not see the stick, but when I watching the video, I see Mr. Bennett.
And who had the stick?
Mr. Bennett.
He had the stick. Did he have anything else?
No.
Okay. Did you see anything like on the ring camera? What was used after the stick?
Can you repeat again?
On the ring camera video footage that you saw, you first saw Mr. Bennett use a big stick.
Yes, sir.
Did you see anything else after Mr. Bennett used the big stick?
The second time he won behind the victim with the brick. So when I went to where he threw the brick to Mr. Boulogne, and I saw the brick on the floor.
Okay. So then you saw on the ring camera, Mr. Bennett threw a brick at Mr. Boulogne?
Yes, sir.
Did you see the brick when you arrived on the scene?
Yes, sir.
Did Mr. Boulogne have injuries?
He got a limp on his forehead.
Did he have any injuries from the big stick?
No.
And you saw the lump on his forehead caused by the brick?
Yeah, of course, yeah.
And you saw the brick?
Yeah.
All of this was on the ring camera video?
Yes, sir.
Was that video footage preserved?
Yes, sir.
Okay. And then you said Mr. Bennett wasn't on the scene when you arrived. Where was Mr. Bennett?
It was walking down on Piedmont. And I found him on 120 Piedmont.
How do you know it was him?
Mr. Boulogne was behind me and identified him.
Okay. And then then you arrested Mr. Bennett?
Yes, sir.
Did you read Mr. Bennett his Miranda rights?
No, sir.
Okay. How did you confirm Mr. Bennett's identity?
When I asked Mr. Bennett for his identification, and he gave me his name, and I want his name on.
Okay. Do you see that? Oh, you ran his name in the GCIC?
Yeah.
And what?
His name come up with his picture.
All right. And do you see that suspect that was in the picture today in the courtroom?
Yes,
Everybody
sir.
can remove their mask.
Can you describe where he or she is sitting and what he or she is wearing?
Yes, sir. Black male wearing a blue navy jumpsuit.
All right. Your Honor, may the record reflect that the officer has identified the defendant, Carl Bennett.
Noted.
All right. Just a couple more follow-up questions. When you saw the brick, can you describe the brick?
It's not a big brick. Is how can I put it?
Do you see anything in the room that's similar sized or anything?
But it's smaller than it's
the alcohol wipes.
Yeah, the box.
It's a little bit smaller, but kind of like the same length and just solid brick.
Yeah.
Okay. How when you saw it on the ring camera, how was it thrown? How close were the parties?
So when it went behind Mr. Boulogne, when Mr. Boulogne came in front of the club, which is 186 Auburn, and he threw the brick.
So they were close?
Yeah, it was close.
And Mr. Bennett was behind Mr. Boulogne?
They were they next each other.
Say that again?
They were next to each other.
Next to each other. Okay, so Mr. Boulogne could see Mr. Bennett with the brick.
Yeah.
Okay. Were there other bricks around?
No.
There was just one loose brick on the street?
Yeah.
And who lives at 186 Auburn Avenue?
Who?
Or what address is 186 Auburn Avenue?
Is it It's a nightclub.
That was a nightclub. Okay, okay. And there was a brick on the street
Yeah.
and no other bricks. Were there any other sticks around?
No.
Okay. When you searched the or when you took Mr. Bennett into custody, what else happened?
Yeah, when I took Mr. Bennett in custody and I doing a search in Mr. Bennett and I found a glass pipe on his left pocket. I don't remember left or right pocket. I don't remember.
Was there any residue in the glass pipe?
No.
It was in his left pocket?
Yes.
Was there anything else in his pockets?
No.
What can you describe what kind of glass pipe it was? Like the shape of it?
Yeah, it was a ceiling glass pipe.
It was, could you see through it? Or?
Yeah, I can see.
Did it have like a bowl in it or anything?
I don't remember, but it was the ceiling one.
So based on your so based on your knowledge, training, and experience, is it consistent with glass pipes used for drug use?
Yes, sir.
Okay. Okay. And you didn't see any big stick, but you did see a decently sized brick that Mr. Bullerman saw Mr. Bennett use?
Yes, sir.
And it caused a big lump on his forehead?
Yes.
And you saw the lump?
Yes, sir.
Were there any other injuries to Mr. Bullerman?
No.
And Mr. Bullerman called 911?
Yes, sir.
All right. And you were post-certified on October 16, 2022?
That's correct, sir.
Right. No further questions for this witness at this time, Your Honor.
Cross.
Thank you, Your Honor. Do you know if Mr. Bullerin sought medical attention after speaking with you?
Yeah, I asked him if he want medical attention. He said no, so he went later.
Okay. In regards to the brick, were you able to collect that brick?
No, I do not.
Okay. And on direct, you testified that this video had been preserved. How has this video been preserved?
So the camera that was on at the intersection is a CD camera. So I was able to open it on fuses and upload it on evidence.com.
And that the relevant time point that's been attached to this case?
Yes, ma'am.
Okay. Do you recall if that camera caught the beginning of this argument?
Yes, ma'am.
Okay. To the best of your recollection, let me back up. When you encountered Mr. Bennett, did he make any complaints related to his physical well-being or health?
No.
Okay. Do you recall if he had, let me back up. So did he provide any complaints about having been attacked himself?
No.
Okay. And then, so it's your testimony that after speaking with Mr. Bullerin, he accompanied you to Piedmont?
Yes, Piedmont, between Piedmont and is 120 and the cross intersection is, I think, is I don't know, John Wesley Dub or something like that.
The video that you collected, does that video have audio?
It's not audio.
Okay. Do you recall if there was a third person related to this fight?
No.
Okay, just one moment, Your Honor.
Okay.
In filling out your report, were you able to obtain contact information from Mr. Buelleren?
Yes, ma'am.
All right, I have no further questions, Your Honor.
Redirect.
Just very briefly, I just want to confirm on the record that this wasn't a Ring camera video. What kind of video?
No, is a the camera is a at the intersection. Is a city camera.
City
the
camera.
intersection.
I just wanted to clear that up. And 186 Auburn Avenue, that's a nightclub. Did you? That's what you testified. What's the name of it?
Is it? Can I see? Can I?
You can take a look at it.
Yeah.
You can't read from, but you can take a look at it.
So yeah, is the wire pickup.
That's the name of it.
Yeah.
Wild
pickup.
Peacock.
Yeah.
Wild Peacock on 186 Auburn Avenue.
Yeah.
Okay. No further questions for this witness at this time, Your Honor.
Anything else, Ms. Correa?
No request, Your Honor.
All right. This is only case?
Yes, Judge.
All right.
May I witness be excused?
Absolutely. Stay healthy and safe out there. All right, go ahead with argument.
Appreciate you. The state submits on the evidence, subject to rebuttal, Your Honor.
All right, Ms. Correa?
Your Honor, understanding that probable cause is a very low burden, we will leave it up to your discretion.
All right, I find probable cause on ag assault and possession of the drug-related objects. I think there's no bond as of October the 17th. Ag assault, possession of drug-related objects. Pre-trial.
In regards to Bennett, multi-state offender, 1 in Michigan, 2 in Louisiana, 13 in Georgia. Convictions, financial transaction card fraud, financial transaction card theft, 3 counts in Athens, Clark, 2019, 3 arrests for probation violation. Also misdemeanor probation for theft by shoplifting and obstruction sentence August of 2022. Nothing further.
All right, Ms. Correa, does he have an address where he'll be living?
Your Honor, with a bond, that is when my social worker can step in and start looking at places with appropriate bed space.
Okay.
As of right now, the address on file is his mailing address. He also resides in the Auburn the Auburn Market neighborhood.
Okay.
In that area.
Sure.
My client is 44 years old. While he does have cycles in other jurisdictions, Georgia has been his primary residence since about 2006. He works as a dishwasher at the restaurants there I don't want to classify it as a strip mall, but it's like where that Mango's Jamaican restaurant is down on Auburn Avenue. That's where he works as a dishwasher, Your Honor, at those restaurants down there. And that's how he has been supporting himself. He was able to obtain his GED. He does have 2 children. Those children are presently with their respective mothers, a 12-year-old daughter and a 7-year-old son. We have spoken to Mr. Bennett regarding placement at a program. He has expressed interest in receiving some kind of substance abuse treatment. He is also comfortable with an ankle monitor once he has been accepted to a rehabilitative program. in speaking with Mr. Bennett, once this case is indicted, should this case be indicted, we would expect to present a self-defense argument, Your Honor. I understand that's not before you today, but just to take that into consideration, I would ask for a bond that would allow my office and the bail project to get Mr. Bennett into safe and secure housing to help his underlying substance abuse concerns.
All right, what says the state?
Yes, Your Honor, with respect to Ayala, we'll submit there is significant danger posed to our victim here, Mr. Luberin, with respect to the multiple probation violations in the multi-state history. We would submit there is a significant risk of reoffending pending trial should a defendant make bond. We are concerned about the use of objects that can cause significant bodily harm in this case. So we'll leave this in Your Honor's discretion.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 186 Auburn Avenue Northeast. No further contact with Lamont Omar, O-M-A-R, Bullerin, B-U-L-E-R-I-N. So you have to provide an address where you're going to be living upon bonding out. 5,000 on the ag assault, 100 on the drug-related objects. Best of luck to you, sir.
Thank you.
Thank you, Your Honor. And I confirm this is the Royal Peacock Lounge.
Yeah, avoid the Wild Peacock Lounge. So stay away from the Wild Peacock Lounge.
Actually, look, it's probably Royal, like R-O-Y-A-L.
Oh, Royal.
Yeah.
R-O-Y-A-L. Sorry, I thought he said wild.
Yeah, I thought it
Royal.
was, it sounds remarkably similar after you do say it. Yeah. But yeah.
So stay away from the Royal Peacock Lounge.
Yes.
We don't have any more officers. What's the status here?
I got one update, I believe. Position 3, Officer Gaines is on a robbery call with drugs involved. He has advised he's not sure if he's going to make it. I'm going to have another update on that soon. Those are all the updates I have right now. I can call our investigator right now. I did text him at 11 o'clock. But at this point, I would just have to make a call. Maybe we could do a quick recess and I come back with
Yeah, I could do a recess. I've got one case that I could probably just bring over here and hear real quickly if I want to stand down for a little bit.
Yeah, for position 5, Mr. Wilson, that's the one where the other ADA that was here earlier provided an offer. I just need time to communicate that to Mr. Wilson.
Sure.
If he accepts that, then he would not be moving forward with the preliminary hearing.
Okay. Yeah, if you want to go ahead and see if you can reach your officers. I don't want to, these
Yes,
folks
Judge.
have to be on with me tonight. It's going to be a marathon
Yes, Judge.
again. Let's see. I'm going to bring this other case in here to.
Quick question, Judge, on position 1, was that 5K and 100? 5K on the ag assault?
5,000 and then $100 on possession of drug-related objects.
Thank you.
Student, you need to see anything?
Hey, deputy, is the door over here open so I can go back here? Deputy, is the door over here open so I can go back here?
It's not the, you talking about the side door?
Where the restroom is, yeah.
No, it's not.
Can you go unlock it so I can go through? Amber, you're gonna have to let me in the back door here, but I'm not. Oh, well, I guess you can. Okay, I'll probably.
Williams. Hey, Williams, real quick.
Well, Liz.
You got codes. Yeah, that's crazy. You got a code to this door? You got the code to this door?
The code to it?
Yeah.
It's a code?
It's a code. Isn't it 2293?
Oh, to the door.
Yeah, no. You got code, don't you?
You just got the code.
It's code.
That's crazy.
I don't know.
Yes, I just had to confirm. Thank you.
What do we got time to take? Gotcha.
Said he hired a postal
Sorry, I'm freezing.
No, I was gonna try to get Judge,
Yes, ma'am.
If you can indulge me for one brief.
Sure.
So I got notice yesterday that my client, Miss Stephanie Holder, that you gave a bond to, is in Douglas County on a probation hold. I just received that call from Officer Marco Diaz, who works in the Douglas County Jail. But the bond that you gave has an ankle monitor requirement, so they had to cut off the ankle monitor from Fulton County in order to take her to Douglas County.
Right.
So now, because the ankle monitor is cut off, the ankle monitor people are saying, well, we now have to report her as, right. So I'm trying to avoid her going onto Judge Drake's calendar for no reason.
Right. So if you want to just do like some sort of order.
Yes, I already typed it up, Your Honor. Okay.
Yeah, just shoot it to me and then she has 48 hours to get it.
Okay, I put 72 hours. Do you want me to change it to 48 hours?
Oh, yeah, whichever, it doesn't matter, as long as she can get back and get it done.
Okay, thank you so much.
It is so cool back there.
Oh, no, that's a. It's a word template that was given to me a long time ago.
All right, so I'll handle this, Miss Hood, while we're waiting on the rest of my people to get here through prelim.
Good morning, Judge.
Good morning. Do we have everybody? I don't see everybody. I just see the two.
I don't see Miss Sullivan. What is the ID number so she can get on here?
Well, I sent it to you. I'm streaming live. I'm not gonna give it out on.
Okay, can you
Same one
send
you
it to me by chat, Your Honor, so I can provide it to her to get on?
Not the same one you used?
It's not.
No, I mean, you used a different one to get here. It's that same one.
Well, unfortunately, I just clicked on the link, Your Honor, so I didn't take
Okay.
down the actual ID number, unfortunately.
All right.
Yeah.
1 second.
Okay, thank you.
And Ms. Lutton, is your client going to be here?
Yeah, so I sent him the same link that I clicked on. It didn't require me to type in like an ID and password, but it's saying he has to type in an ID and password. She didn't send it to the client. She only sent it to me and Miss Hood. So we're able to click on it and it just takes us. But for some reason, the same link that I clicked on, it's not working for him.
There's not a.
Just
there's not a-
at it.
It's not a password. Okay, there.
I got it.
Right, so I'm in the middle of prelims waiting on some cops to get here. We're just waiting on Miss Hood's client. What are we taking up this morning? And we got your.
We're taking up a motion to amend or modify the final order, Your Honor. I'm going to contact the client now via text to give her the information. 1 second.
While we're doing that, we have your court reporter, Mr. Mahoney. Are both parties going to share and take down? Ms. Lutton, are you going to share and take down?
I'll need to ask my client. I'm sure it's fine.
All right, Ms. Hood, are you going to share and take down? Somebody's got the court reporter here.
I do, Your Honor. I'm the one that provided the court reporter for today. So if opposing counsel wants to share the cost, that's fine.
All right, you can ask Ms. Lutton.
He on? Oh, he's on. Okay.
Yeah.
Mr. Sullivan, do you want to share in the takedown for the court reporter today?
Yes.
Yes.
All right. All right, just so y'all know, once again, you both agreed to sign and take down. Mr. Mahoney, I hope you got that down on the record. I require court reporters to be paid within 5 days of receiving invoice. Mr. Mahoney, if you want to send both lawyers your contact information, so and they can send you theirs in the chat, so you'll know where to send the voucher, and then contact me if you're not paid within 5 days of receiving invoice. We'll bring everybody into the courtroom. They'll purge from the courtroom, or they'll purge from Rice Street. So we're just waiting on Ms. Hood's client. You got any updates?
Yes, Judge. Position 3, is on that robbery call. We have the same officer, East Point Y76. Our investigator is reaching out to them right now. Position 10, beware of APP, where we don't have any update quite on them yet. And position 15, Union City Detective Allen, we're getting an update. The investigator calls coming down now. She may have additional information. As far as 16 and 2, it was my understanding that those would be different officers for 16 and 2. This was Tracy Mumford, but it was actually Ron Sager was the officer on all 3 of those, her investigator Paul. So if we can address bond on those.
Well, y'all said there was different officers.
I saw different officers, but Ron Sager, her investigator Paul was supposed to testify on all 3 of those cases.
What, do you want to call that officer back?
I can see.
Yeah, I mean, he didn't act like, he said it was his only case.
She said it was, and then, I mean, that's what our investigator said, but it wasn't, so that's why I'm talking to them right now. I was gonna make that call.
You know the old saying, right, Mr. Lang? Yep. Violated one of the 7 Ps. You remember what those are?
Couple of them. I don't know also.
Proper prior planning prevents piss poor performance. That probably still went out over the air. Could you imagine growing up with my dad and every single thing I did wrong, he's like, you violated one of the 7 Ps. No matter what happened, failed the test, came home, it was like, you violated the 7 Ps. You violated the 7 Ps. It was miserable. He still tells me I violated 7Ps. Oh, Dad, I'm sorry I'm running a few minutes late. You violated one of the 7Ps, kiddo. Sometimes I don't even think he knows my name. It's just kiddo.
Growing up with my family, it was if you're early, you're late. If you're early, you're on time. You're on time, you're late, you're fired.
Yeah. Well, I would be up.
Every single time it was, okay, we gotta leave at 8 o'clock. If I wasn't out by the car by 7:50.
They're gone. Exactly. My dad used to make fun of how he would come in. When I'd come in at night, if I was like running late, he'd hear me like come in sideways into the driveway. All right, now we got Miss Sullivan here. All right, so we're gonna step aside from this. When I get an officer here though, Miss Letton and Miss Hood, I'm gonna pause it because these criminal cases come before them, but I'm trying to multitask here. Miss Sullivan, Mr. Sullivan, raise your right hand, please. Do y'all swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth? Mr. Sullivan?
I do, Your Honor.
Miss Sullivan?
Yes, I do, Your Honor.
All right. Who's starting out? Ms. Letton, or is it Ms. Hood, you're trying to modify something?
Yes, Your Honor, this is just a motion to modify and amend or set aside the final order. As you can recall, we were before the court on September 30th, 2022 for a final hearing. This motion is based upon the order that Your Honor had signed in reference to this matter. The petitioner in this case takes exception in reference to the order that was drafted by Attorney Lutton, who represents Mr. Sullivan in this matter, Your Honor. This motion to modify and amend or set aside is specifically in reference to the paragraph that's outlined in the final order, paragraph 1. As the court may recall that there was a number of witnesses and evidence that was brought forth. One of the things that the petitioner takes exception to is that there was no mention in reference to the May 6th date. As Your Honor can recall, there was a partial hearing that took place on May 6th. And of course, the court may recall there was a lot of resets in reference to finalizing that hearing, in which that final hearing didn't take place until September 30th. So in reference to the May 6th, there was information, exhibits, testimony that was not mentioned in Your Honor's final order in reference to this matter. But specifically, what we take exception to, Your Honor, is that in paragraph 1 in the order, it says as such, the court finds that after the hearing, the evidence and argument of counsel, there's no immediate risk of harm to the petitioner. We don't specifically take exception to that because in the court's ruling on September 30th, the court did indicate that there was no significant risk of harm in reference to the petitioner. What we take exception to, Your Honor, is that in the order in paragraph 1, it stated that furthermore, the court finds the petitioner did not provide sufficient evidence to support her claims of physical violence by respondent. If the court can look at the transcript that was provided on September 30th, or what was taken down, the court did not say that the evidence was unsupported. What the court indicated in its ruling is that on page 5 of the transcript that's attached as exhibit A, line 4, the court said the burden here is the preponderance of the evidence, more likely than not, which is a higher burden. You have probable cause. So I didn't see a whole bunch of proof of anything with the bruising on the neck. She shows us a bruise on her leg, no bruising of the neck. If she were choked, it would use the broomstick to choke her, that there was none of that. I mean, I didn't see but one picture of the bruise on the leg. As Your Honor may recall, the petitioner didn't necessarily just allege that she was choked. She also alleged that she was hit with the broomstick too. So in reference to the petitioner saying that there was not provide sufficient evidence, that's not what the court's ruling was. In addition to that, the petitioner the respondent indicated that although petitioner claimed the respondent choked her with broom, she failed to provide any evidence of the same. But as Your Honor, we can recall there was evidence from the officer who also indicated that he saw some bruising on her leg and also indicated that he was the one who took the picture. In addition, in the paragraph of the order, it specifically says the court did see a photo with a red mark on petitioner's bottom. However, her testimony along with the same did not appear to be credible. On page 5, the court did not make any mention about that she didn't seem credible. As I previously indicated, the court just mainly said that there was one picture of the bruise on the leg, and the court went on in reference to bond conditions that were pending. The court went on indicating to see whether Judge Morrison had an updated status in reference to that. The court went on in reference to advising the respondent to make sure he stays away because the bond conditions weren't modified. And so in reference to that, we take exception because that's not what the court's ruling was when all the testimony had been concluded. Additionally, on here it says petitioner would often refuse to respond to questions asked by respondent's counsel, and she would aggressively argue with respondent's counsel. She would turn her video camera off, and she appeared to be referring to something on her lap during her testimony, and she would argue with the court when asked to answer a question. Well, in the court's ruling, there was no mention in reference to my client turning on and off the camera off, or any mention of anything on her lap. We can't recall is that the respondent made a summarization of her closing in reference to that, but as we know, I'm not the trier factor here, nor is Ms. Lutton in reference to that. The judge, of course, is the trier factor in reference to the rulings and will identify specific facts and conclusions of law in reference to his or her judgment in any matter. So in this instance, this information should be removed because that's not what the court's ruling was. It further says petitioner's demeanor and lack of cooperation in her testimony, coupled with lack of sufficient evidence, led this court to find her claim to be unfounded. And again, Your Honor, we take exception to that because in the court's ruling that's attached as Exhibit A, there was no mention from the court in reference to her demeanor or lack of cooperation. What the court basically said was the court spoke about the bruising on the neck and not seeing a whole lot of proof in that. The court spoke about that there was a picture on the bruising leg. On page 6, on line 4, the court said, so she wouldn't say whether or not she lived in Georgia. Obviously, probably she doesn't, but she did not. She refused to answer that. The house is sold, that was a big thing. He doesn't know where she lives. There are still bond conditions, and there has to be a reasonable likelihood that violence will occur in the future. I don't see that. He has no idea where she's at. So in reference to anything more, the court did not indicate that in the court's ruling. And we're asking that all that information be stricken from the final order pertaining to this dismissal of the temporary protective order. The law is very clear that in any type of motion to modify or amend or set aside the final order, that this court has the power to modify as long as it's in the same term. In this instance, this motion that petitioner filed was made in the same term. Pursuant to OCGA 15316, the court has the power to amend, control this process, and order so as to make them comfortable to law and justice and to minutes on record so as to make them conform to the truth. C. Vaughn v. Fitzgerald, 112 Georgia, 517, 37 Southeastern, 752, 1900 case. What the petitioner is asking, Your Honor, is in the alternative that the court will adopt the petition that we had, or the proposed petition that we had presented to the court in reference to these findings in fact. In the petition that we had provided to Your Honor, we basically made a posture of the case in reference to the May 6th. And I think in reference to doing a final order and understanding that May 6th was part of that final order, there should have been some mention in reference to evidence, testimony, and otherwise. In my motion, I described that there was a lot of evidence in reference to exhibits that were provided by the petitioner. In addition, I talked about the testimony provided by the officer that testified on behalf of Ms. Sullivan in this case. And I also identified the several incidents or occurrences in which Mr. Sullivan had appeared back onto the property on more than one occasion after the April 3rd incident. So if the court should not adopt the proposed petition that the petitioner, we're simply asking the court to just amend it to strike the information that I have indicated to the court regarding the final order, because that's not what was provided by the court's pronouncement or ruling.
All right, Ms. Ludden, mazel tov on the union.
Thank you, Judge.
All right, go ahead.
Yes, Judge. So Ms. Hood's entire argument seems to be that the statement of facts in the current final order should not stand and should therefore be vacated based on the fact that they were not specifically laid out in the verbal ruling. However, she's then asking this court to adopt her statement of facts, none of which are in the verbal ruling. Instead, it's all testimony and evidence that was provided throughout the hearing, as is the current statement of facts. I can specifically point out several pages where the court themselves actually stated and made mention to the issues that are currently set out in the final ruling. For example, page 69, Ms. Sullivan is asked several times to leave her camera on. It also occurred throughout the entire transcript. Page 70, she was told that she was refused to answer the question. She needs to turn her camera on. She needs to turn the camera to look at her face. Page 87, the court made mention that she is looking at something and referencing something in reference to her testimony and what she's saying to this court. Not to mention, Judge, if you recall, you already made the decision. We're here on something where you already made a decision on. I provided my written ruling to the court through email, to which then Ms. Hood responded with her edits, where she quite literally copied the entire final order, deleted it, and then provided what she prefers to be the final order. The judge then reviewed both of our final orders and adopted mine. This has already been decided on. At this point, it is becoming harassment towards my client. I understand that Ms. Sullivan may have family and friends that are willing and able to represent her at a lower cost, if no cost at all. Mr. Sullivan does not have that opportunity. We are now here for the second hearing on this issue, as the first hearing had to be reset, and my client has incurred additional substantial attorney's fees trying to fight this frivolous motion. We are here today, and we're going to ask that Ms. Sullivan be ordered to pay his attorney's fees in the amount of $3,404. And I have my attorney's fees affidavit here provided to show what he has paid since the date that this motion was filed. That is what has been incurred from that date to include 2 hours of my time today.
All right.
And Your Honor, may I speak in reference to that? Now, opposing counsel has mentioned the 9/11 in reference to whether this was frivolous. This is not frivolous, Your Honor. This is based upon justification in reference to the true and accurate, what the record reflect in reference to the court's ruling. And that's why we filed this motion, not for harassment, not to delay anything, but to speak the truth in reference to what the court said. You know, we are not objecting in reference to the significant pose of threat, because Your Honor did indicate that. But these other things that the opposing counsel had drafted in this order is not correct and it's not accurate. And my client certainly has a right to file a motion in reference to making sure that the record reflects what's true and accurate in reference to what transpired by the court. What did the court indicate? What were the facts that this court relied on and specifically said in its pronouncement? And as you can see, Your Honor, as part of Exhibit A, the court did not make any mentions in reference to what opposing counsel indicated in pretty much half of this paragraph. What we're asking is that at the very least, what happened to May 6th? There's no mention in reference to anything surrounding that. And then in addition, all of these things that she has identified in her paragraph are what her closing arguments were, which aren't evidence. And she is not the trier of fact. The court is. And the court made its pronouncement and the court made its ruling in reference to that our client, or that is the respondent, did not pose a significant threat. And these allegations further is not what the court said. In fact, there's, go ahead. I'm sorry, Your Honor. So in reference to my client paying attorney fees, that should not happen because my client had a right to file a motion to amend to make sure the record reflects what took place and what the court said. All we're asking is let the record reflect what the court said in reference to its ruling on that day. I attached the court's ruling. I attached what the court said on that date. And I'm just asking for Ms. Lutton to modify it or amend it to indicate what transpired from your pronouncement, not what she is arguing and what her closing argument. That's not what the court said.
Judge, if I may, first off, she's not arguing against me. It is not my order. It is not my final order. It is not what I decided to put into the ruling. The court already made the decision. The court got her proposed edits, chose not to go with her proposed edits, and made their final order put in place in this case. So I think it needs to be made very clear. It's not Ms. Lutton who she's arguing against. It's not Ms. Lutton who needs to amend anything. She's here today to argue that the court put in an incorrect and an inaccurate statement of facts in their final order. This has nothing to do with me. The court already made the decision. This case has gone on far too long. This case has become harassment against my client. And I specifically, although she tried to state that I didn't, I did specifically ask for attorney's fees in my response to her motion. We're asking that she be ordered to pay his attorney's fees. He does not have the ability to pay them because he has been doing nothing but paying attorney's fees against her for these frivolous actions and motions that continue to be filed against him.
All right, I'm going to let the final order stand as it is. Go ahead with your, you want to go ahead and testify about your attorney's fees?
Yes, Judge. Robert, you have been incurring additional attorney's fees since the date that this motion is filed. Is that correct?
Yes, ma'am.
Yes.
I'm going to share my screen and show my attorney's fees affidavit and bills and invoices. If you will, is this a true and accurate copy of the attorney's fees bills that you received from my office?
Yes, ma'am.
Does it appear to be tampered with in any way?
Not at all.
Not at all.
And is it correct that since the date her motion was filed, you have incurred additional attorney's fees in the amount of $2,704.13?
That is correct.
Okay, and are you asking as well that 2 hours of my time be added on to that for preparation today and attendance at today's hearing?
Yes, I am.
And so are you asking for a total award of $3,404?
Yes, I am.
Which I tender this as, I guess, just exhibit 1, and that will be my only exhibit.
Ms. Hood, you want to cross?
I do, Your Honor, but I'm taking exception in reference to this attorney fees. This is the first time, Your Honor, that I had an opportunity to review this. Opposing counsel had not provided me this the day before the hearing in reference to requesting attorney fees. She was aware that she was going to ask for attorney fees and that I have not received this affidavit to even view, to look at it. So I'm objecting in reference to any information pertaining to that. In addition, Your Honor, as I said, under 9-11-15, just give me one moment so I can provide, Your Honor, the law in reference to that. 9-15-14 is.
I'm willing to send her the invoice now. It's 2 pages. I think she can review it today.
9-15-14 is for litigation costs and attorney fees, Your Honor, for frivolous actions. And that's something that the court will have to determine in reference to it. As I stand before the court, my client had justification in reference to filing a motion. She filed it within the same term of court. She indicated what exceptions that were not provided in the ruling of the court, which was again attached in the exhibit. That was complete justification in reference towards this motion to amend or modify. So in reference to attorney fees, again, my client does not have the funds. In fact, I'm doing this pro bono just to for justification from my client to amend this. So it's not like my client has a lot of money as well. She just started a job, and I don't even know whether she will be able to pay anything. In fact, I don't believe she could pay anything at all in reference to this. So I am objecting to any reference to attorney fees. This is the first time I saw this affidavit or report from opposing counsel. Opposing counsel, when this case was reset, she knew she was going to ask for attorney fees. Back in January, I never received any documentation for that to have an opportunity to review that information. I think it's unreasonable and unjustified for her to now produce it today, indicating that these are my attorney fees.
Well, I think previously in her testimony, she couldn't really get it straight on how much she paid in attorney's fees. She was like, 2, 3, 5, I think she probably said 5,000. She kind of went back and forth and she didn't know how much she had paid in attorney's fees. So now are you saying she's never paid you anything, Ms. Hood, in attorney's fees?
She paid me a little, Your Honor, but not a whole lot, $1,500, and I've been doing a whole lot in this case. So that's why I said pro bono is the only thing. I mean, I'm doing this pro bono. Because I think this motion to amend pro bono.
In the transcript, it was more than 15, but now it's 15. Now it's pro bono. That's the problem. She has no skin in the game. She can sit here and file motion after motion after motion and not have any consequences for it. She's not paying for any of this. Mr. Sullivan just lost his house. He couldn't even keep his house out of foreclosure. He hasn't paid me anything. I am in the hole on this case. I'm not getting paid either. But he's certainly getting billed for it. And he's certainly getting billed for it. And he's certainly required to pay it. But Ms. Sullivan has friends and family who are willing to harass my client and file motion after motion, despite this court having already made a decision on this matter. It's ridiculous. It's absolutely ridiculous. She should not continue to go unscathed, to be able to file whatever motion she chooses to file This was already a decision that was made by the court. First, it was that she paid $2,500. Then it was that she wasn't sure. That now it's pro bono. Well, now she's actually paid $1,500. Judge, it's quite clear she hasn't paid anything. And my client has been paying me over and over as much as he possibly can. And he's continuing.
That's not
to incur
true. That
attorney's
is not
fees.
true.
Ms. Hood, I'm speaking. She's continuing to incur attorney's fees on this case, which has become nothing but frivolous, and which I requested 9/15/14 in my response on the motion. He's entitled to attorney's fees and we're requesting that he be awarded same.
Your Honor, 1915-14 regarding litigation costs states as such. In any civil action in any court of record of this state, reasonably and necessary attorney fees and expenses of litigation shall be awarded to any party against whom another party has asserted defense or other position with respect to which there existed such a complete absence of any justificable issue of law or fact. Again, Your Honor, in your ruling, you never indicated any of that information that the petition that was drafted by the petitioner was provided by the court. The court specifically indicated that there was no significant threat. The court spoke about Georgia. The court spoke about, I didn't see any bruises on the neck. The court spoke about, I did see a bruise on the leg, but the court did not speak about all these other things. She had a right and a justiciable issue of law and fact that she could file a claim in reference to this. This is not based upon harassment. This is based upon just trying to get the record to speak the truth, to be accurate. And all we're doing is making an objection in reference to paragraph 1 in reference to it. The court cannot award attorney fees if it's not shown that we didn't have a justiciable issue of law or fact in reference to this rule NISA. And we're standing on the position that we did, that there was nothing attacked in that exhibit. Nothing in the rule NISA, nothing in the court's ruling in reference to that. There was nothing that the court said about the turn of video camera, arguing aggressively. She just didn't seem credible. There was no evidence of that in the court's ruling.
Again, we're talking about the court's ruling. There's a full transcript of evidence and testimony that was put into the transcript.
One at a time.
If you read what she's requesting, you modify the order on, it's nothing but her statement of facts that she prefers to be put in, none of which were stated in the ruling. So her argument makes no sense. It's not justifiable. She's here to say that the statement of facts should not be in there because it wasn't stated in the verbal ruling. The judge can make any sort of statement of facts in their written ruling that they see fit. Not to mention, it is evidenced by the transcript.
Well, Ms. Lutton, that's incorrect.
Argument that she should not. That it should all
incorrect in reference to
Don't talk over her, Ms. Hood.
She's then making the argument because it wasn't in your verbal ruling, it cannot be in the statement of facts. But then she's then providing a very lengthy statement of facts, none of which was mentioned in your verbal ruling. So I don't understand the argument. It's not justifiable, and this is harassment.
That's incorrect, Judge.
Anything else, Ms. Hood?
Judge, this case came before the court because there were facts that were specifically noted in the final order that was not presented by Your Honor in its ruling. The court, in facts and finding, makes specific facts and conclusions of law. And when you made that ruling, you did not make any of these statements in reference to what took place in reference to the Family Violence Protective Order here. When you dismissed it, the court specifically indicated that there was no significant threat. And that was the basis in reference to dismissing this. And also that you indicated that I saw one picture regarding the bruise or the injury, but the court went on about incidents that were previously occurred that you felt as though that she didn't meet. And the court talked about issues surrounding the bond. My client was justified in reference to filing a motion to amend to make sure that the facts pertaining to the dismissal were true and accurate. So we're asking the court to deny any fees for attorney fees, because one, we never received any type of attorney fees to review. Second of all, the OCJ 915-14 specifically says that it has to be shown that it wasn't justiciable issues or some frivolous or harassment in reference to it. And again, Your Honor, this was not done by harassment.
All right. So anyway, I'm going to deny the motion to modify it. I think it's fine. I'm based on what I remember, and I remember your client not being very credible at all. And then the other attorney they were texting one another. It was pretty obvious. Your client kept turning her camera off, wasn't paying attention. She just kept going against everything I said. So I'll grant the attorney's fees in the amount of $3,404.00. Can make that in $500 equal installments monthly. Ms. Bristow, Ms. Litton, I'm sorry. Take me a little bit.
Excuse me, Your Honor.
Your Honor.
I'm not sure.
Just put on the record that I take exception to that pursuant to.
Excuse me, Your Honor.
Whoever iPhone is, stop talking. So, Ms. Litton, if you'll just shoot me that order, I'll be glad to draft it and have it e-file. Sign it and have it e-file.
Thank you, Judge.
All right.
Your Honor, I just want to put on the record that I take exception to the court's ruling in reference to the attorney fees, that there was nothing in reference to showing that there was any frivolous or litigation in reference to this matter. Again, this motion to amend was based upon justiciable issue of law and fact, and that was the basis regarding the motion.
All right.
Not to harass or frivolous. Thank you, Your Honor.
Duly noted. Y'all stay healthy and safe. Have a good weekend.
You too, Judge.
All right. Who we got back? We got an officer in here?
I have our investigators here to kind of explain some of these no-shows, but just to run back, put the mic on, just to run back through everything. I need to correct the record. Position 16 and 2, there were different officers on those cases. It wasn't all just Officer Ramsager. So we are just going to respectfully ask for resets on those so we can get the right subpoena to the right officers. My understanding is that those 2 officers weren't subpoenaed.
We'll still do bond, Mr. Lang.
Okay.
On those 2 for sure.
Yeah, for 16 and 2. Okay. For position 3, we have heard back from Officer Gaines. He is on that robbery call. Investigator Pauls can speak to that one further. As far as the remaining no-shows, we have 2 from Atlanta Police Department, Officer Dinkins and Officer Figueroa. That's position 6 and 10, Williams and Lockett. We don't have an update on that. Investigator Pauls can speak to that they were subpoenaed, and all APD officers received a reminder yesterday and in the late afternoon, I believe. As far as the other cases after that, we have an East Point Police Department Officer Wise on the other position 7 for Williams, and we have Detective Allen outstanding for position 15. They were subpoenaed as well. Investigator Pauls can speak to that as well. Well, and we would just respectfully ask for reset, since my understanding is all cases that we don't have officers for today, it is their first time on the calendar.
Go ahead, Mr. Lang.
Your Honor, for my 2 positions, positions 2 and 16, I'm first going to ask the court to dismiss for want of prosecution. At one point, it was the same officer, then it's not, then the officers weren't subpoenaed. I'm going to ask the court to dismiss for want of prosecution. At this point, we don't know when this is going to get reset for, when the right officers are going to get subpoenaed. My client was here, had the opportunity to be heard. We did one of his cases, and now we're telling him he has to wait and come back 2, 3, 4 weeks from now to come back once the correct officers have been subpoenaed. I don't think that's fair judicially to my client, and at this time, I'd ask for dismissal for want of prosecution.
This the first time they've been on the calendar?
It is. And just for the record, I said that they were all the same officer. That was never the case. It was 2 different officers from the beginning. Investigator Pauls can attest to that. This it was a mishap on our end. It shouldn't happen again. Yeah.
All right, when can we get on this, on another one, so his client won't have to wait forever? February the 8th, Mr. Lang?
What day of the week is that?
Let's see.
Then that should work.
Wednesday at work?
That should work.
Do you want to go ahead and address bond?
Yes, please.
All right,
And we can just, if the deputies are okay with it, we can just have Mr. Munford stand next to me.
okay. Said February the 8th, right? So then, do you want to reset the one on Dontavius Ellis for Ms. Correa since he's out on a call?
Yes, Judge.
Set that one?
And yes, and it was a robbery call with drugs per investigator Pauls.
When will that one be reset for, Ms. Correa?
Your Honor, I just ask on behalf of my client, while I understand he is currently otherwise occupied at this time, I would just ask that this be a one-time reset. Mr. Ellis has now been in custody for over 95 days without indictment.
Do you want to go ahead and have bond on him?
He is set for your ORCA night court this Thursday. So I will leave that up to your discretion.
I mean, if you want to go ahead and do it, we can do it. That would be.
I guess we can do it because if Thursday doesn't go on like it did last Thursday.
Okay, right.
At least deal with one person.
And what about, let's see.
Now, position 5, the other 88 that was here earlier mentioned that an officer was not going to be here today and did offer my client a consent bond. At this time, my client could not make the bond that was offered. He would like to have a bond hearing today to address bond independently and for this case to have a one-time reset for that officer to appear since I was not apprised of why that officer was not here today.
If I may, Your Honor, that is a special unit case. So I would just ask for the one-time reset on that case. If we were to have the bond hearing, that would have to be done by the deputy DV attorney who was here earlier. All the other cases we can take up on, but that case would have to be handled by the deputy.
Can you call the deputy?
I can call him now.
And what about the Fernando's Williams cases?
That's Mr. Adams' case, apparently, per his announcement earlier.
I didn't see any entries in there.
It was, but he came on earlier and said that he had.
What about Lockett?
Yeah, I'm here on Williams.
We don't have any explanation for Officer Figueroa's. But it was he had noticed, and we just don't have an update at this time.
Ms. Pinto?
We asked for a reset. Yes.
Yes, Judge. I object to a reset on this case. Mr. Lockett's been incarcerated 96 days. Sorry, I need to get my case. Mr. Lockett's been incarcerated 96 days. The officer's been subpoenaed, the officer's been reminded, there's no guarantee the officer would ever could ever show, regardless of when we set the case. So I would ask the court to dismiss from line of prosecution since the state cannot show probable cause.
What says the state?
This is the first time on the calendar for Rocket. Officer was subpoenaed and received a reminder yesterday. Investigator Pauls is here. She can attest to that. So we would just ask for a one-time reset.
What happened to Chief Shearbaum giving them 3 days off without pay if they didn't show up? I thought that was coming down the.
I'm not certain about that.
Your Honor, we've been having some problems with APD in this office as well as, well, we got a liaison person in this office and he's been working with APD to find out where the breakdown is. That's why I sent out the reminders yesterday because I knew we had some problems with the APD officer showing up. So this officer in question, T.E. Figueroa, he was emailed. He was a part of the email that I sent out to, I think, 7 other APD officers that's supposed to be on the calendar this morning. So he has been told a couple of times to be to court. He's not here, but that is something that we're working on to prevent this from happening. So at this point, I do have a meeting this afternoon with our liaison person in the district attorney's office, who will, I would imagine, have some type of contact with APD to figure out how this is.
Well, who are they talking to? Maybe they need to talk to Chief Shearbaum.
Yeah.
He seems to have a pretty open door policy.
So it's a lieutenant over there that I talked with last week. She's aware of it. Of course, she's not happy. I suggested that perhaps she have a conversation with some of the higher ups over there to try to find out what needs to happen. She did mention what you just said about suspension and so on and so forth. Now we're at the point where a memo should be, I would imagine that I'll have to submit an email, or some type of a memo about this so that Atlanta can hold the officers accountable. But at this point, the officer in question was subpoenaed. He was reminded yesterday to be here. Several of his coworkers that was a part of the reminder that I sent out did call me yesterday. So I know that it reached their mailboxes. But Figueroa was not one of them.
All right, we'll give this one final reset, but I think maybe if Chief Shearbaum or APD's not going to do something, I think I can hold them in contempt.
Yes, ma'am. I'll make sure I know the name.
What's that? Yeah.
Chief Shearbunger.
Yeah, call Chief Shearbaum, else I'll get a deputy to go pick them up and bring them in handcuffs.
Yes, ma'am.
If you're gonna arrest somebody, you gotta show up. I did it for 15 years.
I did too, right around that time.
Yeah, so it ain't that hard. But yeah, after this, I'm gonna start considering holding officers in contempt. This is just, I mean, the one that's on the call, I get it, but the ones that just don't show up, I mean, that's ridiculous. But then we'll go forward on bond hearings on everybody since they're here.
Yes, ma'am.
Thank you, Your Honor.
All right, so maybe you want to call that special one. So here we got,
Get in contact with them now.
all right, so this one is Tracy Mumford, and there's still, what, 2 cases left for him?
Yes, Your Honor.
All right, so it's position 222 CP 213235. Tracy Mumford, 81 days without indictment, possession of methamphetamine and possession of drug-related objects. Pretrial came off of that and surrendered that bond on him. And then it's, there's that one there.
And Your Honor's already heard pretrial and the IALA factors on this. Would Your Honor prefer I just give you my asks for each case, or do you want me to do IALA again since it has been a little while?
No, I could just do that. Let's see, 22 CP 213706, 81 days without indictment, possession of methamphetamine and possession of drug-related objects. All right.
So Your Honor just set $2,500 on his first case. I've spoken to Mr. Monfort about his financial means. I'm going to be asking the court on both of these positions to also set a $2,500 bond, making his total bond across all 3 cases $7,500.
All right, what says the state?
We'll just reiterate our prior argument with respect to Ayala. We will submit there is a significant danger posed to the public based on the nature of these cases and the substances involved, as well as a significant risk of reoffending pending trial. And we'll leave these additional matters in Your Honor's sound discretion.
All right, let's see, on the one ending in 3235, we'll make 4,000 and then 2 on count 1, 250 on count 2. No drugs unless prescribed, no alcohol, no weapons. I think before we said stay out of Fulton County unless you're here for court or to see your lawyer. What we're gonna do, sir, is we're gonna put an ankle monitor on you, paid for by the county with a 24-hour curfew, court, lawyer, work, as long as you provide the name of your employer, schedule, the place you'll be working, and the exact location you're going to be working. You have to tell the ankle monitoring company and the state, or your attorney so they can tell the state, right? You can also leave for any sort of addiction issues or anything if they get you into a program.
They're gonna have to.
And on position 16, 22 CP 213607, 4,000 on count 1, 250 on count 2. Ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, work, as long as you supply the name of your employer, location, proof of employment, and the schedule you'll be working to the ankle monitoring company and to your attorney so they can supply it to the state. Stay out of Fulton County, sir, unless you come in here for court or to see your lawyer. Don't get gas in Fulton County. Don't stop for lunch. Don't do anything. Come to court and leave. You got it? All right. He said in the affirmative, yes. Thank you, sir. Best of luck to you.
We have the special unit ADA here. if you want to.
Down here?
Yeah, if you want to take up that matter next, for everybody's convenience.
So which one is that?
Position 5, Wilson.
Okay, William Wilson?
Yes.
Ms. Correa? William Wilson?
Or they could talk.
Yes, sir. See you this evening.
Yes, ma'am.
When they just set up the indictment list.
64, 65 people, I think. So.
Bostic, this one's gonna be William Wilson. So, Mr. Adams, they don't have your, the officer here for your case. We're gonna reset it for one reset, but do you want to go ahead and be heard on bond?
No, we'll wait for a reset. When can we do that, John?
So you don't want to be heard on bond yet?
No, yeah.
All right. What's the reset date on those two? It'll be February the 8th. And that's the Williams case, right?
Yes, John.
All right.
Okay, thank you.
All right, have a good one. All right, let me get back to this. This is William Wilson. It is 22 CP 213250, 101 days without indictment. You got a charge of aggravated assault. Pre-trial.
Only prior arrest was in 95 and was dismissed.
All right, go ahead, Ms. Correa.
Thank you, Your Honor. My client, Mr. Wilson, is 60 years old. I will note that the incident location, it is a family property homestead, and that is where he would be residing. It is the address that is on file. That's where he lives with his mother and his sister. His mother is a 4-time cancer survivor, and because of all of the treatment has started to show signs of dementia. His sister also resides in the home, and she broke her neck a few years ago and is largely paralyzed, so Mr. Wilson has been the primary caregiver to his family members. He is a lifelong resident of Georgia. He does have 2 adult sons that live in the area. One had a grandchild recently, and Mr. Wilson has only been able to see that grandchild twice prior to his arrest. Prior to incarceration, he was working as a truck driver. My client himself has had his own unfortunate run-in with cancer and was in the early stages of receiving treatment for lung cancer as well, Your Honor. While we do understand that these are, at this stage, these are allegations, and we understand that these allegations are severe. At this time, I'm asking the court to issue a one-time reset for an officer to appear for the preliminary hearing and to set a bond on today's case. At this time, I'm asking Your Honor to consider setting a $5,000 bond, as Mr. Wilson has now gone without employment, any way to generate any income. Any money he did have saved has now gone to supporting his dependents. And so that is the reason for my $5,000 request. And we are fine with a no contact order. It is our understanding that the complaining witness in this case has been trespassed from the property and is not allowed to be on that property and has since relocated to Douglas County.
Okay, that's Ms. Wilson.
I believe it's Melissa Sweat. I don't believe that they have any romantic or otherwise, no family relation, no legal family relation.
Melissa Sweat, okay. All right, what's at the stake?
Good afternoon, Judge. With respect to the bond, the state would just simply be asking for a $15,000 bond, which I think is appropriate and consistent with similarly situated allegations involving a defendant with no prior felony history, which I would agree with that I don't believe the defendant does have any prior felony history. The allegations are that the victim was strangled by means of the defendant blocking her ability to breathe through her nose and through her mouth. When the officers arrived on scene, the defendant himself admitted to placing the victim down on the ground and shoving mud in her mouth, although he did deny any allegations of strangulation. However, his admission at least corroborated part of what the victim said happened to her, which was that she was taken to the ground. The defendant placed mud into her mouth, and then he subsequently blocked her airways and her ability to breathe through her nose and through her mouth by placing his hand over her mouth. Given the allegations, the state is just simply asking for a $15,000 bond, a no contact order with the victim, Melissa. I don't know if it's pronounced Sweet or Sweat. The last name is spelled S-W-E-A-T. And that is all from the state, Judge.
All right.
And then I apologize, Your Honor. The only, I'm not disagreeing with any of what the allegations are. I just forgot to mention that I have been in contact with Mr. Wilson's ex-wife. Although they are divorced and she has remarried, she and I have been in contact regarding Mr. Wilson's well-being. And so he does have other people in the area there to support him. You know, I can't say I would be able to say the same for any of my prior significant others, but for a remarried ex-wife to come to his aid, I think is telling, Your Honor.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Melissa Sweat. $8,000 good bond, sir. Best of luck to you.
Thank you, Your Honor.
Thank you, Judge. May I be excused?
Yes, sir. Thank you.
Thank you.
Thank you. Go. Yeah. Appreciate it.
Well, we got Ms. Pinto. You want to?
Ms. Correa, can I ask y'all a question about Mr. Carr?
Yes.
Did y'all not do his cases because they were being indicted?
I had emailed the judge privately asking for them not to go forward today due to a pending ex parte matter. It was later today that we found out about the indictment, which, you know, is fine.
Because only one is on the list.
Yes, that was my understanding. When today, nothing was going to happen in Mr. Kerr's case.
Okay.
Ms. Pinto, you want to handle Tavarius Lockett?
Yes, please, Judge.
For a bond?
So everybody left is just bond?
Yeah.
Okay.
Yes.
So Tavarius Lockett.
And did we get a reset date on this one, Judge?
I think she's giving them all February the 8th. Is that right?
February 8th.
How you doing, Mr. Lockett?
You can stand right here, Mr.
All right, we got position 10, 22 CP 213339 Tavarius Lockett, 96 days without indictment, possession of controlled substance marijuana with intent to distribute. Pre-trial.
Lockett has 25 cycles. Let me go back to it. I didn't make a summation. 25 cycles, a couple of felony convictions for drugs, few FTAs, drugs, 3 felonies, drugs, parole violation, felony theft by receiving stolen property, another parole violation, ID theft, fraud, aggravated battery in 2013. And that was his last conviction, and he has a hold. Let me click on that. The hold is for probation violation out of Barnesville, Georgia. Nothing further.
All right, there's a $2,500 good bond as of October the 21st. Go ahead, Ms. Pinto.
Thank you, Judge. Mr. Lockett has been incarcerated 96 days with no indictment and now no preliminary hearing. He is 41 years old. He has he went to the 12th grade, but he didn't graduate. He did look into the GED program at the jail. However, they told him that he, in their opinion, wouldn't have been there long enough to do it. He does have two children. One is 22 years old and one is 2 years old. The 2-year-old is currently living with her mother, but of course, Mr. Lockett provides for the child when he is out. He's a lifelong resident of Atlanta. He's not a flight risk. If we do have a good address for him on Kipling Street, which is where he'll reside and where he'll receive his court notices. At the time of his arrest, he was working for a temp service called Go Jobs. He had just started there. And prior to that, he was working for a lawn service company. He does have a hold. For probation. He has 2 months left on that probation, Judge. We're simply asking for a UJR to the hold so that he may deal with that. Given that who knows how long this Fulton County case is going to take.
All right. What's his estate?
Yes, Your Honor. Defendant has a $2,500 good bond. He would submit, given the charge in conjunction with the nature of the history, that is more than reasonable. That's abundantly fair. We'll respectfully ask that Your Honor allowed to remain. With respect to Ayala, we'll submit there is danger posed to community based on the possession of these substances with the intent to distribute. We have 5 grams of marijuana, $100 in small denominations consistent with the sale or intent to distribute. His defendant was asking witnesses, how much do you want? Additionally, we'll submit there is a significant risk of reoffending pending trial, given the nature of the history, and we are concerned about that whole out of Lamar County. Nothing further from the state.
All right. Is he going to live in Conley, Georgia?
No, Judge, it's an Atlanta address.
Oh, okay. All right. Let's see. He needs to, no drugs unless prescribed, no alcohol, no weapons. Stay away from 3843 Jonesboro Road. And I'll reduce this to a $2,000 good bond. Best of luck to you, sir.
Thank you, ma'am.
Could I just talk with him briefly?
So we got Amaria Madian.
Yes, Your Honor.
Yes, absolutely.
Thank you, Your Honor, for the last
Looks like it's 15, Bostic.
$15,000. Oh, 15 with a $15,000 good bond.
Okay. Oh. So you have to take them all down to bring her up.
Oh, is there any more males up here?
There are bills up here.
I mean, did I need to hear?
There are some.
Oh, Dontavius Ellis.
Yeah, I guess, yeah, just to.
All right, yeah, we'll make it easier. We'll do those. Sorry, Dontavius Ellis, position 3, Bostic.
Yeah, thank you, Your Honor.
Yeah. You've got so many markings on here, I can't tell.
Are we hearing 3 or 15? Which one we hearing first?
3. All right, this is position 3, 22 CP 3237, 102 days without an indictment. Possession of cocaine with intent to distribute, possession, willful obstruction of a law enforcement officer, misdemeanor trafficking in cocaine, illegal drugs, marijuana, or methamphetamines. Pre-trial.
Extensive criminal arrest history, 25 prior arrests, 32 years old. 3 arrests for probation violation, has a hold in Gwinnett at the time of his arrest, if he's been in there since. Nah, never mind. At the time of this report, open sale of sale of marijuana, probation 2016. On probation also for possession of cocaine from 2012. One of those Judge Lovett's sentencing for 30 years. Also open case 21 SC 178186. Nothing further.
And there's a $45,000 good bond as of October the 17th. Whenever you're ready, Ms. Carrera.
Thank you, Your Honor. Just really quick, Mr. Ellis is 34, not 32. Not a big difference, but just to be clear, he does live at the address that is listed on his pretrial report, which I believe is also the one listed in Odyssey. That is where he resides with his mother and grandmother. His mother has lupus. His grandmother is blind. There's also a 19-year-old and a 10-year-old at the home as well. My client is a lifelong resident of Georgia. Since his incarceration, I believe he now has a new baby.
No, due June 18th.
Due June 18th. I take that back, Your Honor. But, well, a baby on the way, as well as 4 other born children. He graduated from Job Corps with his GED, as well as certifications in window tint and landscaping. Prior to incarceration, he was working at the CCT warehouse, delivering kitchen cabinets. So he was gainfully employed. The Gwinnett County hold is, I believe, related to a probation matter there, likely stemming from this new arrest. At this time, he does have a $45,000 bond. A significant portion of that is related to the trafficking charge. At this time, Mr. Ellis and his family are unable to make that bond, so we welcome any reduction that Your Honor is willing and able to grant.
All right, what says the state?
Yes, Judge. The state is respectfully asking that Your Honor allow the $45,000 good bond to remain with all conditions. With respect to Ayala, we'll submit there is a significant danger posed to community with the alleged, with the possession of these substances, 30 grams of cocaine, additional cocaine in other bags. There was a pursuit of the defendant through a parking garage involved here where he abandoned some substances under a vehicle. We are concerned about that. Additionally, there is an extensive criminal history here. Given the defendant's age, he became at 18 in 2006 with 25 cycles. That is a concerning ratio to the state, particularly given the multiple family convictions in multiple counties. Seen an aggravated assault conviction from 2012. We are concerned about that, as well as open cases and probation violations here as well. More than three probation violations per the pretrial report. We would submit there is a significant risk of reoffending pending trial here. And given the nature of the open probations, we'll submit there is a risk of not returning to this jurisdiction to face the charges. We'll ask that all conditions remain. Nothing further from the state.
All right. Let me get this one back up. All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 300 Peachtree Street. You're gonna have an income monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, or work. You need to supply proof of employment, name of your employer, schedule, and exact location you'll be working. And sir, I'll also let you leave if you have to take your mom to see medical appointments. I don't want her to miss a medical appointment because you can't leave. But when you take your mom to a medical appointment, what you need to do is you need to let the ankle monitoring company knows what you're doing, okay?
All right. Yes, ma'am.
All right, so that's 7-4 5, and 15. 7, 5, and 15. Best of luck to you, sir.
Thank you.
Do we have a reset date for his preliminary hearing?
I think that one's February the 8th also.
Okay, February 8th. So we'll come back.
Judge, can you repeat those conditions for me one more time?
7, 5, and 15,000.
The condition, ankle monitor.
I have paid for by the county with a 24-hour curfew, court, lawyer, medical appointments. He can also go to medical appointments with his mom. And since his grandma's blind, and work as long as he supplies name of employer, proof of employment schedule, and the exact location where he'll be working. He has to provide that to the ankle monitoring company and to his lawyer, who can provide it to the state.
Thank you.
Thank you, Your Honor.
Thanks. And his reset date for his prelim is February the 8th. Now, that should be all the men back there, right?
What was the situation with Williams and Carr?
So Williams is reset. Carr, those, I think he was indicted.
Yeah, you can call me.
That's Miss Correa. Did you go back and tell him?
Tell who, sorry?
Carr?
I can, Your Honor.
Okay. I mean, if you
I will
want.
do that and then they can all go down.
Yeah, Williams is reset, and then you can bring up that one female.
Gotcha.
Thank you, Your Honor. Okay. Yeah, we got one more year. Well, it's same place at 88 Pennington. Thank you.
Whose bond is up next? Is it, Manyan?
Uh-huh. Yeah. Boston, you looked at all the calendars for tonight? Boston.
They're going down, they will bring Miss Mannion up.
Okay.
Are we on the record right now?
Yeah, but you want to be.
No, is that a murder Kroger sticker on your water bottle?
Is it what? Yeah, Kroger.
The murder Kroger one?
Yeah.
I have that as a magnet.
Yeah, they had the stickers at Ace Hardware.
Oh, wow.
They don't like it when you call that anymore.
Well, that's too bad. It has its own computer.
Right.
It's outside their control.
Right. When you live here, it's just kind of what it always is. But you know, they closed the Disco Kroger.
That broke my heart. My mom used to go to that nightclub
Yeah.
back in the day.
Before it was the Kroger. Do you know that, Ambria? The Disco Kroger right there on Peachtree at
In Buckhead, it's Peachtree and Piedmont.
Piedmont. The Kroger, it was called the Disco Kroger. It had the little disco ball. It used to be a club before it became a Kroger.
Yeah, they kept the disco ball range.
That's why we called it. Yeah, right. They got that rooms to go and everything right there, right where Piedmont and Peachtree cross. You cross over and it's in that shopping center on the left.
Okay.
Yeah. It used to be a club. Yeah, they left the disco ball. That's why you call it Disco Kroger. Yeah, they want the new one to be called Beltline Kroger. It's like, no, it's just always, yeah, it's always murder Kroger. Yeah, I think tonight's pretty big again.
Are we off the record? I got a question about that.
No, you got to be there, Boston.
No, that's not the question.
What's the question?
I understand there's a such thing as add-on, like you add 1 or 2, 3 or 4, but how do you add a whole additional calendar?
So that 10, they had to add those. Those were from the power went out at the jail and they didn't have access to Zoom.
I get that. You add there, don't have 4 add-on calendars. That doesn't make sense.
Yeah, so it's that one and there's a long one on Thursday and then it should be back to normal.
Well, you can cancel.
I'm quitting ORCA calendars.
All right, so on Thursday's calendar, you can remove Mr. Bennett, you can remove Mr. Ellis, and you can remove Mr. Wilson.
Bennett, Wilson, Ellis, which one?
Ones we're doing today.
Just Bennett, Wilson, and Ellis, that's it?
Yes, Your Honor.
Okay, see what I did there? When you do the bonds, when you have the prelims, helps. All right,
It should always be that way. I mean, the person who's doing the prelim hear more of the facts.
well, that's why I hear it. Okay, I may mispronounce your name, ma'am. I'm sorry. It's 15. 22 CP 213578, Amaria Madian, 88 days without indictment, hindering apprehension or punishment of a criminal. Been in jail 88 days without indictment. There's already a 15,000 good bond that was set by Judge Freeman, and then Judge Hughes kept that in place as of October the 31st. Pre-trial.
No prior arrest.
I apologize, are you waiting on me, Your Honor?
Sure, go ahead.
So first, as it relates to this preliminary hearing, I would ask Your Honor to consider dismissing the charges as the officer is a no-call, no-show. This is from not Atlanta Police Department, I know that much. This is a case from Union City, and an officer should have appeared regarding this case. Returning to the bond portion of this argument, Your Honor, Ms. Madian is 18 years old. She has resided in the metro Atlanta area since she was in the 5th grade. The address on her booking report and in Odyssey is her good address out of Stockbridge. I have been in contact with her father, Mr. Madian. That is his home, and that's also where her brother resides as well. Other connections to the metro Atlanta area is a Miss Nicole. Miss Nicole is somebody who has stepped into a motherhood figure for Miss Madian and helps provide guidance when she can, since Miss Madian unfortunately is not in contact with her mother. Miss Madian made it as far as the 11th grade, and at the time of her arrest was working as a homemaker, so that way her father, who is in advanced age and works up, his shift can often exceed 10 hours a day. So Ms. Madian does work as a home care provider, so that way he is able to do that so he can provide support for his family. Per Ms. Madian's pretrial report, she did qualify for an unsecured judicial release. If Your Honor is not inclined to grant that unsecured judicial release or the dismissal, I would ask Your Honor to consider reducing this bond to $5,000. Thank you.
It says the state.
Ms. Bostic, if you could mute.
She's calling to try to pay her cable bill so her internet won't stop. What says the state?
Yes, Your Honor. The state appreciates the lack of criminal history here. With respect to Ayala, we'll submit there is significant danger posed to Markel Knight and the public. The allegations are concerning. It was a concealment of a firearm used to shoot Markel Knight and fled with the suspected shooter in an Infiniti 2005 per warrants. We'll leave any modification in your Honor's sound discretion, and ask that all conditions remain, including no further contact with family members of Markel Knight and no weapons.
Can you tell me who was the perpetrator in the alleged shooting?
I do not have that information right now, Your Honor.
Okay, so we got no drugs unless prescribed, no alcohol, no weapons. No further contact with family members of Markel, Markel Knight, and whoever the alleged perpetrator is in that shooting.
Yes, Judge.
So I'll reduce this to a $10,000 good bond. Let me see if there's anything else I was going to put in here.
If we could have a reset date. All right.
So that'd be a $10,000 good bond. Best of luck to you, ma'am.
Thank you, Your Honor.
And Judge, that was a no contact, no alcohol, no drugs, no weapons.
Oh, yeah, no further contact with the family members of Markel Knight. That's the victim who's deceased.
Okay, thank you.
that all we got? Sweet, we're done. Thank you, Bostic. Thank you, Ms. Jones. See y'all this evening. Anything else we need to take up before we stop the stream?
Nothing further from the state. Yeah.
All right.
And then I had just emailed you a transport order for your consideration.
Okay.
Other than that, nothing for today's calendar.
Okay.
Nothing for today's calendar, but just for advanced notice on your night court calendar tonight.